Yes.
But may I have my lord's kind leave to mention a matter upon notice? My lord, it's a very old two applications. One is for urgent hearing, and my lord, one application for reconstruction of documents. My lord, I am told that the documents cannot be found. My lord, it is a very well-known mark, Sony. It's a passing of suit, my lord, very old suit, my lord. There's a full bench with regard.
It means what? We appeal is there.
Yes, my lord. It is from Alipur Court. My lord, it was referred to a full bench because there was a divergence of views. So that's why
Full bench is,
my lord Justice Aniruddha Bose held that even if it trade in different goods,
but it has to be assigned to a full bench.
no, it was the full bench decided on it and
Oh.
said the matter was remanded back to the division bench to decide on the interim application.
My lord, may I have your lordship's kind leave to mention, my lord, these are all applications, group 2 matters. There were, my lord, I'm telling you, my lord, 8 matters were there. 1 has been decided, 7 are analogous. So, my lord, by that order, it can be decided.
May I have my lord's kind leave to present on memorandum appeal with the server copy. The order was passed on 8th of October. The Honorable Single Judge has directed the West Bengal University, Maulana Abul Kalam Azad University, to grant a college a particular course.
Whatever you want, when you have applied for certified copy.
Lordship, on 8th, I have applied 8th of October on that.
Okay.
Lordship, the original I have sent for, Lordship, kindly.
And annex, no,
Yes,
annex
yes.
the copy of the application
Lordship, I'll.
with the memo.
May I have a lordship's kind leave to mention matter for hearing, your lordship. Hearing matter, your lordship.
What hearing?
Appeal, first appeal, your lordship. Paper book is ready.
Which year?
2012. 2012, your lordship.
New determination has come. Up to 2020, another bench.
Up to 2016, your lordship.
Up to 2020, another bench has been given.
Which,
I am mentioning one order 41. Order 41.
Of which year? After 2020?
Yes, yes, 2024.
Group 2 primary matter.
What applications give?
My lord, may I be permitted to mention to my lord, take up the matters on upgradation 109, 1010, 108. 2 are analogous matter related to career advancement scheme promotion, my lord. One is suffering from
Where
cancer.
you were when the entire list was called?
My lord, I was always, my lord.
Even on Monday, nobody was there.
My lord, then
Yesterday
sorry,
also.
then sorry, my lord. I extremely
Just
sorry.
wait. We'll take up.
Kindly fix the date, my lord.
Not fix
One
it.
is
We'll
suffering
take up.
from, my lord, one is suffering from
We will take
cancer.
up- We'll take up all the matters. Every litigant before us is equal. If they have approached, let them. We'll take up. Don't worry.
My lord, upon notice, I have come.
No difference. We'll take up. Yes.
My lord, may I be permitted to mention one matter for correction? My lord.
Our order.
Yes.
My lord, may I be permitted to mention to file an appeal by server copy without certified copy? Order passed yesterday. I have duly applied.
Certified copy.
I have applied.
Annex.
Extremely good.
my lord's kind leave may be permitted to mention on 7th October 2024, a order was passed, my lord. The name of the essential party has been wrongly written, my lord, for correction, my lord.
Our order. 7th October. You were not there.
7th
You were there.
Chutopa Chakraborty, Fat 525 of 2010.
Whose order?
My lord's your,
Both of us.
my lord. Madhuresh Prasad.
Justice Madhuresh.
That is what I am saying. He is
Correct,
not
correct.
understanding what I. So how can you do it?
Madhuresh
দেখো তো এই হবে না কেন? Now order passed by whom?
Justice Madhuresh Prasad and my lord.
Go before him. Correction. You wanted a correction.
No, last order was sitting with Justice Madhuresh Prasad.
Me.
Yes,
No,
my lord.
no, order dictated by Justice Prasad. Your lordship agrees.
Oh, that's with me.
Lordship, one humble reliance, lordship. I just checked the determination of your lordship. First appeal up to 2015 is with your lordship determination.
Today the determination, partial modification has come.
Oh,
Justice Sobasachi Bhattacharya is sitting with Justice Uday Kumar, given an order 41 till 2020
22.
and all the appeal till 2020.
Order 41. Item number 22.
Maybe. The different number, yes, or different. One and two, they are the appellate. The plaintiff filed a suit for declaration of title. A recovery of khas sir. The plaintiff's claim title on the basis of record or right.
Defendant has failed to produce evidence to prove that their predecessor considered. Sorry. Recorded public forum or how the defendant will be recorded on. Never took any steps to correct access and completed on the basis thereof. Police. Yes. What is the point?
Prayer. Suit was dismissed. But the plaintiff is claiming title on the basis of Sadr Ali. Or that's on the basis of record or right. Appellate also has page 9. But there is no
Public arrest copy or student the name of the citizen. And having right to exit the suit but still recording such as the family of the so starting with holding better time. Yes.
in my submission, people lost it. But the plaintiff claiming title on the there is no other document, only record of right. Nothing else. And appeal court also he has. Record does not create any title. I know. But it's rebuttable. So your losses not that this is Supreme Court is on also. He has to go better.
The appeal shall be heard on the following substantial question of law. Whether
23,
We'll dismiss all. All the order 41 will dismiss. Yes.
twenty-four,
Yes. Dismiss.
25,
Revise how the appeal lies. It's a miscellaneous appeal under section 9 of the Public Premises Eviction of Unauthorized Occupants Act. Against that, how second appeal lies? The revision of it. It's a revisional an appeal before the district judge under public premises. Against that, it's not a second appeal because it's a miscellaneous appeal. Revision will lie.
Yes, revision.
Where is this Ishani Ghosal? Who is
Ishani Ghoshal.
Ghosal?
Kindly see in the Vakalatnama whether she sits in room number 5.
10 Old Post Office Street, care of J. Das. Look at it. Joydev Das. D'accord. Considering
26.
Your Lordship, I'm on the behalf of the respondent.
You have no right of audience unless the admission is done. It 106 এর suit. এই দেখুন আপনাকে অ্যাপলেট করে জাজমেন্ট দিয়েছেন এটাই গল্প বলছি অ্যাপলেট কোর্টে জাজমেন্ট তাকে দেখুন সুটে হবে শুট করে ঠিক আছে প্রথম দেখুন pollution, then pedestal, then plaintiff's addition, ঠিক আছে, then so on. এই যে অরিন্দম চক্রবর্তী আমি অনেক সময় বলছিলাম অরিন্দম চক্রবর্তী so my understanding of law and observation is 16. Yes, 15. My understanding of the law. দেখুন সব শুরু হয়েছে ট্রান্সফার অফ প্রপার্টি অ্যাক্টের মামলা নোটিস dismiss. Next.
Your Lordship.
27.
My lord, I am for the appellant. So far as so far as defect is concerned, my lord, it is noted by the stamp reporter that the name of the respondent number 1 doesn't find place in the memorandum of appeal. My lord, the respondent number 1 died on 2nd October 2022, and my lord, his son is already on record, my lord, as respondent number 6.
Respond. Was there any application?
Somnath Das, no, my lord, I have not filed any application. My lord, Somnath Das is the son of late Utpalendu Das, and Utpalendu Das was the appellant, respondent number 1 in the lower appellate court.
Seek a permission leave to proceed.
My lord, yes, absolutely.
So why you have not?
Absolutely, my lord. I should have filed an application for indicating that after the delivery of the judgment and before filing of this appeal, he has expired, my lord.
Yes. What is the matter about? What is the matter about?
Yes, and the plaintiff's suit has been dismissed by both the courts below. My lord, suit for declaration and my lord, cancellation of the deeds. My lord, after the
What
point before
cancellation?
the point for consideration before your lordship is this, whether after execution of the deed of trust and property has been vested in the deed of trust, whether the said property can be gifted by the person who has created the trust to somebody else.
No, it has been held that it is not a trust. It is a will, in fact.
Yes, the court, that it was held by the learned judge in the lower appellate court, but
Yes.
learned judge in the trial court held that it is a deed of trust, and the point has been answered in favor of the plaintiffs. If your lordships kindly see the judgment delivered by the learned trial judge, issue number 4, my lord, your lordships will find, my lord, that the issue that has been raised, my lord, 3, 4 and 12 at this internal page 8 of the learned, the judgment of the learned trial judge, my lord, your lordships will find, my lord, the learned trial judge held that this is a deed of trust and not and it is the suit is maintainable. That has also been held. Kindly come to an internal page 14 of the judgment delivered by the learned trial judge. Middle
No.
post the. I'm sorry, Malad.
It has said that though you have said that it's a deed of trust, but it is nomenclature is a deed of family settlement.
Kindly, Malad, I am handing over to your lordship the copy of the deed of trust, Malad.
You are a plaintiff.
I am the plaintiff. Kindly come to the internal page 2 of the deed of trust. It is কস্য শুভ নিরূপণ পত্র ও চিনামা deed of family settlement and trust.
No, it is that after the demise of the defendant number 1, the trust would stand extinguished.
Yes. Yes. Now, my lord, I have.
And then you will become an absolute owner thereof.
My lord.
So defendant number 1 has not died as yet.
Defendant number died, my lord. Defendant number died. Now, my lord, the
defendant number 1 died.
Died.
When? During the pendency of the suit.
Yes. Yes. I filed the suit against defendant number 1. After the execution of the deed of gift by the defendant number 1. Now, my lord, during the pendency of the suit, the defendant number 1 expired and his there, my lord, has been substituted.
It is a registered document or not a registered document?
Registered documents.
The appeal shall be heard on the
28,
28, your lordship.
28, your lordship, I am praying for an adjournment. My lord, the matter may be adjourned till 20th, my lord. Mr. Anand Banerjee is appearing in the matter, my lord, for the appellant.
So why up to 20th?
My lord, I have been informed, my lord, some instructions are required and one defect is also appearing as I saw in the list.
Let us see the defect.
The advocate on record is also not present today. Over phone, my lord, I have been informed.
Deficit court fees are there.
My lord, I shall inform. I shall inspect once and I shall.
My lord, I'm
Sorry.
the respondent, private respondent.
It appears that the instant appeal is filed with the deficit.
Twenty-nine,
Only your name, nobody's name. Yes. You बोल रहे हो। देखो, seen the report of
thirty,
license की मामला liquor shop के BHO और circuit was after NTC was not state license. So original rules is a municipality they purchase it, don't prove it, no evidence is there. It should be possible. This is a project. Dismiss.
31,
I appear for the appellant one. Defendant is the appellant before your lordship, suit for eviction.
Why you have not paid the deficit court fee? There was several directions which were passed for putting in even a Lojima court passed an order. Who is Mr. Prosenjit Devna? Yes, in your presence, Order was there. There is a deficit court fees of ₹1. Just 1 minute. Oh, now you have put it, sorry. Later on you put it.
My lord, suit for eviction on the ground of reasonable requirement. My lord, judgment of affirm.
Yes.
Only ground I have before your lordship is that no local inspection was done.
Is it imperative?
May I just,
The accommodation is not disputed, then is it imperative?
your lordship would kindly take the trial court's judgments, only one paragraph, and I will be reading the
Yes.
appellate
yes,
court's judgment, how the court has dealt with.
Yes, yes.
Your lordship would kindly take the trial court's judgment, issue number 5 and 7. The court has dealt with the issue of reasonable requirement, and there were many shop rooms in the suit premises. There were many
So
shop.
why he has chosen you, not
Yes.
the other?
That's the usual.
Usual difference.
And my lord, she requires it for the official purpose, for the office room. She has, that is her claim made in her plaint. And in the appellate stage, we took out an application for local inspection since they had not taken out. And
What local inspection? There is only one room which is there for office purpose.
but so far as
All
what is
other
the
rooms which are available in the ground floor are tenanted.
no, so far as my lord, what is the entrance? Which side is the entrance? Whether it would suit the purpose of office room or not? That, my lord,
The tenant will say that whether it will suit to your purpose, it will not suit to your purpose.
well, of
This
course,
room is more convenient.
but I
Everything the
cannot
tenant will
squeeze
dictate
the,
to the landlord.
my lord, of course, I cannot squeeze the landlord, my lord. It is the landlord's prerogative, my lord. That's there. And there are other vacant rooms that I wanted to bring on record.
What vacant rooms on?
Your lordship would kindly take.
Not a vacant room on the ground floor, nothing.
Your lordship would kindly take appellate court's judgment once. My lord, during my place it before lordship.
Yes, yes.
Internal page 6, during the hearing of the appeal, the appellant restricted his contention mainly on the point that no local inspection is preferred by the respondent to show the portion in her occupation, and unless and until such inspection of the premises is done, it is not possible for the court to conclude that the question of requirement. The argument is refuted by the advocate for the respondent by submitting that in the cross-examination, DW1 admitted that amongst all other shop rooms in the premises, the appellant's shop room can be accessed from the main road as well as from the roadside, and as such the suit room is the best room to act as an office room for the
So you
ceremonial house.
yourself has admitted that all shop rooms are tenanted and he wanted for commercial purpose. What more?
So for office purpose, he required.
Obviously, will he go on the first floor or a second floor in where the residential accommodations are there? Your junior does not know. Anyhow, prompting. Justify your appearance, that's all.
That's all the case I have. I cannot go beyond the record. My lord, I have checked the the evidence also.
Have you not brought any judgment in your support?
My lord, judgment.
There is one judgment of Justice Torun Kumar Chatterjee as his lordship then was of this court. In your favor.
My learned senior is live and let live. Live and let live.
Oh, there is no concept of comparative hardship
In our rent
as the
control.
West Bengal
West Bengal.
Tenancy Act is concerned. So live and let live concept is not there. If he requires, requires. If he does not require, does not require. It has to be judged on the parameter of evidence.
The only
Both
thing,
subjective and objective, both.
only thing, my lord, local inspection was not done. And not
There is a clear admission on your part that the entire shop rooms, all the shop rooms are tenanted. You said that this shop room is accessible from the entrance. So what more? That's your own admission in the evidence. Yeah, let him say, let him say. Let him. No, let him clear his conscience. He may have some point. What he's saying. Yes,
But what is there on record, my lord, I must be
that's
present.
true. What he's saying. Any other point?
There are other shop rooms also which were also vacant that time. That
You
place-
could not prove it. Rather, your admission and by a two under TW1, he read, you have said all the shop rooms are tenanted. What more? Appellate side, the appeal court's judgment, just read DW1 in the cross-examination has said so. Can you improve as a lawyer? You have to go by the statement of your witness. Yes, that you can't do that. Show him, Mr. Banerjee, show him that portion which you read. Show him that portion.
other shop rooms in the premises, all other shop rooms in the premises are vacant cases.
Is your admission, sir?
Tenanted also.
Yes.
এটা
Yes, sir.
এন্ট্রান্স কোন দিক দিয়ে প্যাসেজ আছে এবার যখন এটা রয়েছে কোন দিকটা ও নেবে সেটা মনে থাকে এবার তার আগেরটাও আমি বলছি যে সবকটা যদি tenant এই দেখো সেপারেট সার্ভিস করে এবং এই বাইরে আমাদের
What, my lord, ultimately he has to face the client, that's why my lord.
What?
No, nothing.
Hmm?
That's the
So
best.
the point which he's arguing all are settled against you. There are cutting out the judgment of our High Court and the Supreme Court that the landlord is the best judge of his requirement. It is not imperative that if there are other shop rooms, the tenant cannot dictate the landlord that you evict him, not me. It's the choice of the landlord, whom to evict. Secondly, if the requirement is for commercial purposes, then whatever accommodation available to the landlord for residential of no consequences. Once he proved the commercial purpose, finish. If all the tenants, all the rooms are tenanted, shop rooms, no difficult. Then what is the requirement of commission? There is nothing. Why the commission local inspection is required? It is only for two purposes. One is to ascertain the extent of accommodation, and secondly is for the purpose of partial eviction. And if it is a one room, there is no question of any partial eviction by making a partition within the room. No. So what remains, sir? Nothing. Your senior has tried. Yes, yes. আজকে listen to for us. Concluded.
Right, in number 27, my lord, defect is cured, kindly record that, my lord. Just now your lordship admitted the appeal, my lord, there was a defect. The respondent number one's name was not find place in the memorandum appeal, but my lord, he has expired. Yes, is the respondent number one in the appeal. My lord, he has also, my lord, taken this.
তুমি নিয়েছো? প্রথমে যেখানে
2,
Yes.
33,
Order 44. Taken of first. Yes.
34,
Logic. Suit the box.
35,
আমরা এখানে পরে ক্লিক আপ করি কোনো অসুবিধা নেই ঠিক আছে ঠিক আছে তাহলে বিজনেস তো
Discuss.
Order for the such a facility.
Let the matter go out of this. Let the matter go out of this.
out of it. পঁয়ত্রিশ তো হলো নাকি? হ্যাঁ 35 হলো তো 36 out of it.
Let's look. So,
This was 37
My lord, learned counsel for the appellant, Miss Choitali Mukherjee. She came to the court for she felt sick. She left for the day.
he has not come to the court.
She came to the court, but unfortunately she felt sick, and she left for the grave.
He left.
Yeah.
What was the-
I'm like 38
On behalf of the appellant and paying for not this week, my lord.
Why?
Like Mr. Roy is appearing in this matter. I have just received the brief, my lord. I am not well
Mr.
prepared.
Roy.
He is in courtroom number 16, my lord.
There are many Mr. Roy. That's why.
The Parthapratim Roy, lordship. Parthapratim Roy.
Let us see. Down. On it.
But I want a non-appearance. Okay. Respondent কোনো এ নেই যেখান থেকে নাম নাম করতে হবে করতে হবে
Yes. It's madam. Statement of fact.
Title suit was preferred by the plaintiff opposite party, my lord, which was affirmed, being angry by that order, my lord. Appeal was preferred by us,
Yes.
which was dismissed, my lord. Hence, this second appeal, my lord. I have just received the brief.
Was
my lord.
allowed, decreed.
Suit was allowed, my lord.
It was decreed and then,
Preferred an title appeal, my lord, which was
yes,
dismissed, my lord. Hence, this second appeal, my lord.
point.
Just received the brief, my lord.
Why you received the bill?
Mr. Roy is appearing in courtroom number 16.
Yeah. Passing it over. Can you to come and tell?
Asal kores.
Necessary interest.
39.
Disposition.
ফাইলটা কোথায়? আচ্ছা, আর ফাইল।
কেন শুরু করতে গেল আমি বুঝতে পারছি না। শুধু শুট করো ছিল পার্মানেন্ট দ্যাটস ইট। নট ইন্টারেস্টেড। First appellate court file.
Party.
The defects pointed out by the stamp reporter, if not removed within 2 weeks from date, the appeal shall stand as follows.
My lord, in item number 41, my lord, Mr. Anindo Haldar is appearing for the appellant, my lord. Due to an accident, he is suffering with a leg injury, my lord. He is possibly will join from the next week. Kindly grant us a week of accommodation, my lord. Much obliged.
Party-two.
My lord, in this matter, Miss Lipika Chatterjee is appearing for the appellant due to medical emergency. She has not come today. I am praying for not this week, lordship.
To see the defect. The advocate has record is directed to remove the defects pointed out by the staff reporter. Not the name of your.
Lord, Lordship has gone through. Lordships have gone through the Lord judgments. But though the Lord the judgment of affirmance, Lordship kindly come to page 10 of the trial court first. There was no commission. And Lord,
Necessary
the
for commercial purpose. We may have a residential room, 5 rooms. That does not mean.
and Lord, the evidence Lord is not corroborated. There are Lord, the court noted that there are 14 rooms in the ground floor. The PW2 has said 14 rooms. PW1 said 13 rooms. And Lord, it appears that PW2 said that 5 rooms are still under lock and key. And that apart, Lord, kindly see it appears that it is for business purpose. He requires it for business purpose. But evidence.
Document is produced.
No, document is produced. Not only that, Lord. He has been.
I'm asking, are you saying?
Yes.
I will not say that.
No.
I'm just saying, are you saying that?
Yes, no document has been produced, and that apart, Lord, he has been keeping that room, particular room he is in possession, he has said, under lock and key. And Lord, kindly see, therefore, he doesn't require the suit premises for the purpose of business. Lord, Lordship, kindly notice, Lord, that Lord, page 10 of the trial court, but none of the parties has made any inspection commission over the suit premises to bring a clear picture. Lord, if the evidence, oral evidence shows that it is all right, but oral evidence is totally contradictory. And Lord, our specific case that he has kept from filing of the, before filing of the suit, 5 rooms under lock and key, and during pendency, 3 rooms.
It says that the 5 rooms are under lock and key. But whether that lock and key possession is with the person or with the other persons, with the tenants, that is not known.
Well, that has been said by the.
No, it is not. It says under lock and key, not in their possession.
Well, PW2 has said.
What? That they have put the lock. No. He says that the 5 rooms in the ground floor are under lock and key.
Yes.
Whose possession is there is not disputed, it's not there.
But the PW.
A tenant who was there must have put a lock and key.
No, PW2 has said otherwise. There is no corroboration.
No.
He has said it is tenanted and they are in possession. He is running business. But contradiction is there. But to come to a more specific conclusion in the matter, there must be, this should be ascertained. And the plaintiff has not other businesses, cold storage, share in the rice mill, and Lord, he doesn't require at all for reasonable.
So cold storage does not require. So he's a very renowned businessman.
And Lord,
he want something for commercial purpose. There is a difficulty. It is his property.
Yes.
So
but Lord, he must reasonably require it.
that is a more subjective.
And Lord, it is no other suitable accommodation. He requires 1 room for the purpose of business. If it appears from the evidence itself that another room is there, vacant room is there, admittedly. So kindly see, the learned courts bill has recorded that there are 14 rooms in the ground floor. He said, Lord, that has been on the basis of the evidence on record. And the plaintiff says that 13 rooms are tenanted, including his room, in possession. Another room is there. Lord, kindly see this. Lord, I am a business. I am running my business. That is the only source of my livelihood. If it is taken, Lord, for this malafide purpose, he has said that it is his business to let out the property. It is the admitted position. And Lord, our specific case, and Lord, it has been corroborated by the DWs.
There is a protection which is given in the Act itself. If after getting a decree on the ground of reasonable requirement, if you let out, then you have a right.
He has let out after filing of the suit. That has
evidence.
Evidence is there, Lord. It is Lord. Lord, in the
It was a room for to another person.
Lord,
the pendency of the suit.
In the pleading, we have stated, Lord, the evidence.
Have you proved it? Nothing.
And Lord, the DWs have said that during pendency of the suit, those have been let out. It has not been taken into consideration.
Scrap of papers, then no case can be decided. A person will come and plead, and then he will come in evidence and orally say there is no document, and the court has to believe because he has pleaded and he has said in the evidence. Is this a way to decide?
No, not only that, Lord, the plaintiff has not given a suggestion that it was not let out during pendency of the suit to the DWs. There are 2 DWs, they have corroborated that yes, at the time of filing of the suit, there are 5 rooms vacant, and after during pendency, 3 tenants have been inducted. Lord, kindly see the evidence on record.
Not a single scrap of paper.
No, how?
One or they should be called as a witness to say that yes, I was inducted as a tenant on such and such date.
Lord, the tenants, existing tenant will never go against the landlord.
What are you talking about?
Because Lord, they are in the good book.
There are many cases you have handled in your career. I was also there for a pretty long time. The evidence comes, the rent receipt comes, everything comes. There is no difficulty.
Lord, your lordship kindly see.
You can get it because it's a commercial one from the corporation. The trade license is issued.
Lord, kindly see.
It is applied for.
Lord, kindly see this
is evidence, sir. If you are so genuine, you could have brought those evidence.
Yes, Lord, I have brought.
Why you did not brought the trade license of those gentlemen?
Lord, I have brought the
applied, on a particular date.
Oral evidence, Lord, I have brought.
Evidence is sufficient without corroboration of the documentary evidence.
Lord, documentary evidence is not possible. It is.
Why not possible, sir? It's a commercial property.
Not only commercial.
Somebody is doing a business, he must have a trade license. Otherwise, he can't.
Yes.
And if he has applied, you could have, under the right to information, you know your right from the corporation or municipality or whatever. You could have applied. Give me information about this premises. How many trade licenses have been issued?
So the learned courts will have decided the matter on the basis of simply oral evidence.
Sorry.
So
If he says that he's there and there is no proof that he's got an alternative, chosen a wrong person.
Lord, kindly see, Lord, this,
Chosen a wrong person.
Lord, Lord, your Lordship, kindly consider this. The
We are
case,
coming and dictating.
Lord, kindly see that the order judgment has been passed on the basis of oral evidence simply. No documentary.
Your Lordship, mentioning for item number 26 on mistake of no, sir.
We are in the midst of the matter. Where is a copy of the plaintiff statement?
Lord, your lordship kindly see
Where is the copy of
the evidence. Lord, evidence.
copy of the plaintiff?
Copy of the plaintiff. Copy of the plaintiff. একটা করে যাচ্ছে আরেকটা নেই টেন্টের একটা করে নেই Lord, one WS is there. Lord. My lord, take my copy, my lord. One copy is there. WS and print. This is the print.
আরে দুটো একই
ये দুই হচ্ছে 97 22 64 ঠিক আছে এভিডেন্স ওখানে গিয়েছি ঠিক আছে
মাসিক 532 টাকা ভাড়ায় দাঁড়িয়েছে মিসেসের ভাড়াটে টাকা ভাড়াটি সত্য এই প্রতিবাদী কর্তৃপক্ষের টাকা সত্য তা নয় নাই নালিশ প্রকৃতকরণ হয়েছে নালিশ নম্বর নালিশি ক্লাসের হইতেছে উক্ত দিকে শ্রেষ্ঠ পুষ্প দিকে মস্ত রাখা প্রতিবাদী করা অবস্থা বাতিল ইউনাইটেড ব্যাংক ভাড়ায় বিল দিয়েছে প্রায় 500
হ্যাঁ ওই তো
সত্য নয় যে অনেকগুলি ব্যবসার উপযুক্ত premises দেখাট অবস্থায় চাবিতে বন্ধ অবস্থায় আছে, যা সত্য নয় যে প্রতিবাদী বাদীকে মাস মাস ভাড়ার টাকা দিতে গিয়েছিলেন, যা সত্য নয়। বাদী ভাড়ার টাকা দিতে নিষেধ করেছেন, যা সত্য নয়। বাদী বলেছেন premises ব্যতীত অল্টারনেটিভ বা রিজনেবল বা সুটেবল আছে, যা সত্য নয় যে নালিশি premises বাদীর মাঠের খাস দখল পাওয়ার প্রয়োজন হয়। সত্য নয় যে বর্তমান রিভিউর সময় নালিশি সঠিক আমরা বাদীর খাস দখলে থাকা, যা সত্য নয় যে কারণ আমরা ক্ষতি Office, office of Sister Council or use it. Yeah. It is going to be for great thing. Send it to us.
না আমাদের আমার প্রাইস আপনি করে দিয়ে দিন আমি
ঢুকলেন আমি অ্যামাজন দিয়ে তাদের কিছু বিল্ডিং প্রেমিসেসে নিজস্ব ব্যবসার জন্য ব্যবহার করে। বিল্ডিং এ আরো 5টি প্রেমিসেস বর্তমান মামলা মকদ্দমা দায়েরের সময় বাদী বর্তমান মকদ্দমা চলাকালীন বাদী রাজস্ব বিল্ডিং এর একটি করেছেন ভাড়া বিলির জন্য রেডি অবস্থায় আছে।
Yes.
Yes, Lord, kindly take the evidence, Lord.
I have taken it.
Lord, I have given, Lord, thanks.
You say is not correct.
Lord, I have,
You have taken certain portion, but latter portion is.
Lord, I have, Lord, just not, Lord,
Please,
take,
latter portion
Lord,
is
kindly,
clarification.
Lord, kindly take the PW2 once.
We have taken. PW2 is nothing. PW1 is a very important witness.
Lord, PW,
Because he requires the truth message for his purpose.
but PW2 is supporting him.
Oh, that's true. But PW1 is a principal
Yes,
person who
that
requires.
is so.
And he has put a denial which you have taken in your defense. Everything. You said that there was no sufficient. Everything he has denied.
Lord, kindly once, kindly PW2, Lord.
Please, please.
Lord, kindly see the PW.
Don't go by one straight
Not
sentence.
one step. Lord, kindly as a
Yes,
whole. Lord, kindly see in chief PW2 সে নালিশি প্রেমিসেস ব্যবসার জন্য উপযুক্ত স্থান হইতেছে। নালিশি বিল্ডিং এর একটি কামরায় বাদীর ইলেকট্রিকের ব্যবসা আছে। বাদী has not said so. বাদী has said that I have kept it under lock and key. Lord, next. বাদীর উক্ত একটি কামরায় ব্যবসা করিবার মালপত্র রাখিয়া বিক্রয় করার প্রচন্ড অসুবিধা হইতেছে। বাদীর নালিশি বিল্ডিং এ
So he wanted to expand his business. What
that
more?
is so, I am telling what I am, Lord, kindly see, Lord, ইলেকট্রিকের ব্যবসা চালাইতে হইলে বাদীর নালিশি ঘরটি একান্ত প্রয়োজন। কিন্তু দিস ইজ ইন চিপ। নালিশি প্রেমিসেস ছাড়া বাদীর ইলেকট্রিকের ব্যবসা সঠিকভাবে চলিতেছে না, বাদীর অন্যত্র কোথাও ব্যবসা করিবার নেই। দিস ইজ নট চিপ। Everything has been made up for the purpose of eviction. Lord, now kindly see the cross examination of PW2.
I do
But
not
in
know
this,
why he was brought as a witness. PW1 was sufficient enough.
I cannot say for what purpose and how he requires the suit premises. Next,
Yes, said.
I cannot say for what reason he has filed the present suit. This is PW2.
God, because
It must be more corroborated with the chief.
Only to support. Main principal claimant is the PW1, who is the plaintiff. He says, I require. You said these rooms are vacant, these rooms are under lock and key. He explained, this is the room which is in occupation of these tenants. He named those tenants. You said that some of the tenants are your uncle. One he admitted, but he says maybe an uncle, but he is my tenant.
Yes.
Maybe my uncle.
But
my tenant. I have nothing. He has said there are 6 floors, flats in the second floor. I am occupying one. You are not concerned.
Lord, first floor, second floor, immaterial. Your lordship.
It is under the occupation of the bank. You said 500 square feet of area is vacant. He says nothing is vacant. Another person is already there as a tenant. Everything he has said. If there is a discrepancy in the PW2, who has no role so far as the requirement is concerned, which is subjective.
Lord,
subjective.
Lord, I am the discrepancy of PW1.
One is to be taken into consideration.
Lord, I am that is why I am, Lord, pointing out discrepancy of PW1. Your lordship.
No.
Yes.
He has simply said these are the 5 rooms, correct? These are under these tenants. 6 rooms, you said these are under these tenants. What more?
Lord, kindly take.
Wanted to expand his business. Who are you to stand in the
Lord, once, Lord, kindly take PW1. I'm just pointing out. PW1. Lord, the learned courts below have recorded that there are.
Please, PW1.
Yes.
Sure, PW. Sure.
Lord, kindly take page 4. There are total 3 rooms in the eastern side of the suit building, in one of which defendant resides. As well as whatever he is in tenant. One of the rest 2 rooms under lock and key. The other room, in the other room, there is shop of Pranab Kundu.
So Pranab is the tenant.
And Lord, I have not filed any suit for eviction against Pranab. But the one rest 2 rooms, one is under lock and key.
What is this? Under lock and key of who?
Lord, here the PW2 has said this is in possession of plaintiff. He has said specifically his knowledge that his this is in possession of the plaintiff. So kindly see, I am telling. PW2, Lord, he has said.
We do not want it. What he says is this.
He says, specifically says, this room is in possession of the plaintiff. Lord, kindly see.
Yes.
PW2. Lord, your Lordship. Page 1. Cross examination, Lord. There are total 3 rooms in the eastern side of the building. The extreme north room of the 3 rooms stated above is possessed by Gautam Kole for his business. This is not tenant. It is appellant before it. The room to the extreme south of 3 rooms stated above is possessed by the plaintiff. Plaintiff says it is under lock and key. And Lord, your Lordship is saying that whether it is under possession of tenant or plaintiff, there is nothing. But he has said it is under possession. Not a fact that the room possessed by Amitabh Kundu is under lock and key for last 3 years. Lord, he says plaintiff himself, my Lord, is relying upon the plaintiff's evidence. He says, PW1. He is plaintiff.
Whose requirement is?
Yes. He says that it is under lock and key.
That's true.
And this PW2 says that it is under his possession. Next, Lord, kindly see from the description given in the evidence, it will appear that there are total 13 rooms in the ground floor. The learned court recorded 14 rooms. The PW2.
That's wrong. We will say 13 rooms.
No, 13 rooms.
We will say 13 rooms. No, don't worry. We can substitute. If there is a minor discrepancy in the judgment of the trial court, we can rectify.
No, not trial court. It has been, Lord, from the evidence of PW2, it is corroborated. There are 14 rooms. Kindly see, Lords. But the PW2 corroborated that there are 14 rooms. And the learned court below has also recorded there are 14 rooms. Lord, kindly see this. Well, I have been evicted for no reason at all. The PW2 has been set up. He said it is required for business, but he says in the cross-examination that I do not know why this suit has been filed. And not that apart, Lord, if there are so many rooms, at least it appears that 2 rooms in possession of the plaintiff. He says that he is in possession of 1 room. Lord, then, Lord, the eviction, I am a tenant. It's a beneficial legislation, Lord. Your Lordship knows, Lord, recently the Honorable Apex Court has also held that Section 2G, that has been, Lord, given a go by. It has been held that it is heritable right.
I know. I have seen that judge.
Lord, that.
I have no. But
Now, Lord,
this is not a case.
No, I am not so.
And I do not know whether the Premises Tenancy Act applies.
Premises Tenancy here?
Yeah.
No. But here I'm not on that point.
I saw one sentence. I am asking because the notice was under Section 106. I am asking whether the Premises Tenancy Act has been extended to this area.
Premises Tenancy Act? Yes.
Extended.
Yes.
Applies.
Yes.
Lord,
this is Arambagh municipality. Applies. And Lord, kindly, I am saying so in view of this fact that beneficial legislation, and Lord, kindly see the tenant, he is evicted for no reason. He is Copy of the printed copyটা দেয়া আছে printed written statement
ও দিয়ে দাও ওই সব কাগজগুলো দিয়ে দাও রিটেন স্টেটমেন্ট প্লেন্ট এভিডেন্স
তিনটে জিনিস দিয়ে দাও
এক্সিকিউশন স্টিতে লাগতে হতে হবে দিয়ে দাও
ইয়েস ম্যাম
আরো আছে তো
আরেকটা আছে
because it will require for 47 and all everything.
Taboo starts after the degree.
Forty-four. Item number 44.
এটা নিচে রাখ
Yes.
45. Forty-six.
From Jabbar, I'm playing off today. It's Jabbar, playing off today. I 46.
Where is she?
She's now yes, buddy.
Call her.
Sheet. The guest will come at 2. Dinner to come at 2.
I shall inform.
First person needs a
47.
47, my lord, I am appearing for the appellant, my lord, appellants. This matter was heard, my lord.
Of plaintiff in the trial court.
I am, my lord,
You are a defendant or plaintiff in the trial court.
we are the defendants.
Defendant.
I am for the plaintiff.
What is the suit for?
This was suit for cancellation of a compromise degree on the ground that
Compromise degree.
the
Decreed
map,
by both the courts.
no, blood, trial court
Dismiss the suit.
dismissed this suit.
Appellate court reverse.
Allowed the, dismiss, allowed the appeal, my lord. First appeal.
This challenge was thrown on the ground of fraud.
Yes, my lord. Fraud.
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 Fraud was proved.
No, blood, that fraud was not proved.
Not proved.
No, my lord. Lord, moreover, one substantial question of law, my lord, if a compromise degree is challenged before cannot be challenged in a separate suit, that can only be
Order 23, Root 3A.
Yeah,
Yes.
and in this regard, blood, there are several Supreme Court judgments. Order 23, or Order 23, Rule 3, capital M. And this matter was heard by your lordship earlier, lord, on 2 occasions, lord. And but no decision was given.
Our view was against you.
That is regarding the map, regarding the allegation is there were 2 maps are prepared, and the actual map which was to be produced was not produced. Another map was produced. What fact is that, my lord, the compromise degree was entered into, signed by both the plaintiff.
What was the terms of the compromise?
Compromise was in favor of the plaintiff of the suit in this case. 1/12 share declared in the preliminary degree, and that was compromised, my lord, and she was given. She even sold out almost all the properties except one, and making allegation that regarding that property, the map is
The
not.
allotment which was there in her favor has been wrongly shown.
Yes, well, that is allegation that his
Show us the law that under Order 23, Rule 3A, the suit on the ground of fraud is not maintainable.
Maintainable, my lord, I have brought at least 3 Supreme Court judgment, my lord.
On the ground of fraud, it is not maintainable. Please.
Maintainable, that separate suit is not maintainable.
This is what I am asking. The separate suit on the ground of fraud is not maintainable.
Maintainable, but that they can, if there is any grievance, he can.
First, you show us the plaint. Let us see. Show us the plaint that what relief they have sought. What? Show us a judgment. Supreme Court, you are talking about.
Yes, ma'am.
We are waiting that you will be.
No, my lord, I am.
You will be handing over to us the judgment.
First one, my lord. The judgment has been reported 2012 5 SCC, my lord, page 5 to 5, my lord.
Yes.
Para 11, my lord.
Yes.
Para 11, my lord. Last portion, my lord. As such, a party challenging a compromise can file petition under proviso to Rule 3 and Order 23 or an appeal under Section 96 of Section 1 of the Code, in which he can now question the validity of the compromise in view of Rule 1A of Order 43 of the Code. So, but cannot file separate suit.
Where is the subsequent judgment? Yes. Good. Okay.
There are other 2 judgments, Lord. Please do not report it, Lord, but judgment of the Honorable Supreme Court, passed by their Lordships, Lord, the Honorable Justice A.M. Khandilwalkar and Ajay Rastogi, Lord. I am relying on para 14, para 14. There is another judgment plot reported in 2021, 9 SCC, page 114. Blood, para 44. Para 44, I am reading.
Where is the plane? What are you giving? The suit simpliciter for permanent injunction. Where is the declaration of the compromise degree to be void? Yeah. Yeah. Yes, they got to the server. Making injunction, please. Thank you.
No, no, no.
Where is the plate? Injunction application you have forwarded?
No, my lord, that is not with me, my lord. Plaintiff is not.
What is this? Sir, you are arguing a point which is based upon the plate. And you do not carry a plate. And you do not know a difference between an injunction application and a plate.
No, my lord, that is given by my learned friend, my lord.
This one, injunction application.
He has given.
Where is a copy of the plate, sir? He has given and then you have forwarded.
I've already,
This is the injunction application. Zero, zero.
Solenama degree and my lord.
Plaint, which you filed, sir. You filed a plaint. I wanted a plaint of your case. Plaint of title suit number 99 of 2017, sir. He'll come to find out a plaint. He does not know difference between plaint and the injunction application. Please assist him to find out.
I'll certainly. এটা তলায় আরো তলায় এক্ষুনি দেখলাম আমি একটা এটা দেখি তার তলায় কেন বনাম
Find
লেখা
out.
ছিল
We are coming
My lord, an extremely urgent situation, my lord. Order 21, Rule 99, my lord, has been allowed. Degree, my lord, was obtained against a person who is no longer in this world. Taking recourse of that degree, my lord, I am being thrown out. The learned judge has dismissed my application under Order 21, Rule 99, saying, my lord, that I have no right to the property, my lord. Overlooking, my lord, the rent receipts which have been given, which have been produced, which have been proved. The learned judge says that in an application to Order 21, Rule 99, I have to show continuous, my lord, rent receipts, which is, in my respectful submission, completely perverse. 8th is the date fixed for delivery of possession. Today, my lord, with police help, today, my lord, Justice Bhattacharjee has been pleased to release the matter, my lord, because it was filed as a first appeal. So it went there, my lord. His lordship was pleased to, my lord, convert it into FMAT. And, my lord, it has to. The problem is 24. Problem is it's from City Court. And your lordship would not be taking it up. Kindly, my lord, if your lordship, my lord, passes and publishes a list, my lord, so that if you're.
supplementary list করে দাও আজকের জন্য for release.
Yes. So grateful, my lord.
না প্লেটের কপি আমি
mentioning one matter, my lord, at number 37.
আর
বলে তাহলে কিন্তু ফুলে আমাদের চার নম্বর কর্তৃক ভ্রান্ত অংশগত আমাদের প্রস্তুত করা আছে
for 2 p.m. There is a oh 2:30. এখন কেন ডাকছো?
Item number 31, my lord, it's been dismissed, my lord. Kindly.
Yes.
Item number 35. They're dismissed, my lord. Kindly. Kindly. I come late, my lord.
Are you ready with the matter?
I'll add, kindly, yes, tomorrow I will.
No, today itself. If you argue, we will not.
Kindly, after half an hour, 1 hour, my lord.
After half an hour.
At 3. Okay. Item 35.
35
The item number 46 is concerned some defect is there, my lord. In the cost title, my lord.
What kind of a description is given in the cost title? A deceased person is arraigned as a party here.
My lord, there is some mistake it had been.
What mistake? How long you are practicing? For a pretty long time. Then you include a deceased person as a party in the proceeding. We are discussing.
No, my lord, I'm praying before your lordship. Your lordship, give me chance to correct the same. My lord, on her behalf, I am praying apology. It was my duty. It was my duty.
They will not correct themselves unless they suffered. So this time let her suffer.
No, my lord, litigant will suffer. Litigant will suffer. My learned advocate, my lord, the litigant will suffer. It is a matter of recovery of possession and my lord, injunction. Your lordship give me first time I am praying apology on her behalf. I am praying apology. Give me chance to.
Apology is not accepted.
Adjourn. Yeah, my lord.
Dismiss with liberty to file fresh.
Then my lord, limitation will
has to be.
It will for the my lord, reopening your lordship.
The reopening is over.
Maybe the first time I appear before your lordship give me chance. One chance, my lord. Don't, my lord, on the basis of the wrong, on behalf of the learned advocate, why, my lord, I am asking myself, why litigant will suffer? It is our duty to assist the court properly. It is our duty. For that reason, my lord, I am praying apology.
That's why I say this is not a proper assistance.
Henceforth, she will not do something, my lord. I am a person, my lord.
Unless she suffers, she will not learn.
Your lordship knows, my lord, your lordship. For the ends of justice and of natural justice, your lordship give me chance. One chance. Any further, any more, again, then your lordship dismiss.
So
with cost.
We are not dismissing, but imposing cost.
Imposing? Very poor person. Very poor person.
What person?
Huh?
What are you talking about?
Yes, very poor person. The appellant before you left, very poor person.
And she has engaged you. Poor person. Believable.
Your lordship. No. I am praying, my lord, again apology. Again and again, my lord, it is the court and also the learned advocate. It's not the litigant. So, my lord, litigant should not be suffered on the basis of the wrong done by the learned advocate, my junior friend. I am on her behalf praying apology. Last chance, my lord, give. And don't be harsh, my lord. I am praying before your lords. Don't be harsh. First time and last time. It is a first and last time I am praying before your lords on her behalf for the interest of the litigant, my lord.
The advocate record of the appellant is directed to delete the name of Another matter at the 2 p.m. vacancy. Sitting. Daily vacancy.
The defendant is the appellant. Defendant is the appellant before your lordship. In a suit for declaration of title and recovery of possession.
It has already been declared in favor of the plaintiff in the first suit. Second suit filed by you seeking a counter declaration, hit by res judicata, dismissed, affirmed by first appellate court, dismissed, and then again second appellate court dismissed. What more? Third suit again for declaration. I am really surprised. Why declaration? It should have been only permanent injunction.
No, it is a suit filed by the plaintiff on the ground that he was dispossessed in the 1991. And for recovery of possession, this suit was filed. Suit was decreed by holding that in view of the earlier pronouncement, the status between the parties has been crystallized by holding that the plaintiff.
What more? Where is the wrong?
Now, my lord, can you consider whether, my lord, whether.
Substantial question of law.
Constitution also
Patadar, outside. Can you go into this?
Only one thing, my lord, I draw since paragraph 26 of the title appeal. It was held the limitation point was urged by the defendant. But the appeal court has refused to entertain on that ground that it was not raised before the trial court. So the limitation point is a mixed question of law and fact, and therefore that can be urged before the first appellate court also. If I have the pleadings to that effect.
What limitation for declaration?
No, it is their suit for declaration.
So no limitation. Anytime invasion of a right under section 34 maintainable.
Yes, my lord, from within 3 years.
No.
From the cause of action, my lord, can you consider what is the cause of action for him?
Every day when there is an invasion, every day is a recurring cause of action.
That is, if, my lord, it is pleaded in the plaint in such a manner that the cause of action arose from that date.
Cause of action is not a straight date or something.
It is a bundle of facts.
So, you have lost in your suit, you lost in his suit, nothing more, nothing less. Hey, Mr. Deva. For order.
এত বড় কিছু হয়েছে
You have gone through the judgment. I was surprised that why he again filed a suit for declaration. Not necessary.
For a
permanent injunction, nothing or recovery, that's all.
Permanent injunction, only for execution of the permanent injunction will suffice the purpose if there is a disposition after permanent injunction degree was passed.
Call the next. আমার গ্রাউন্ডে রিলিজ করতে হবে। Yes. Let's go the next.
নাম দিতে হবে
Disappearing. Valuation.
No, but in the supplementary list matter, may we only will pray for the server copy will today so that we can.
Unless we sign the
That's
order, we have already instructed to go and just
so grateful.
do it. It will be
Great.
signed within half an hour.
So great. So
Who is appearing in 48? Dismiss.
Item number 49, my lord. The medical record, Mr. Sulika Maiti is medically unwell. That's why he has not come to the court, my lord. I'm praying for Mr. Sulika Maiti is not well, sir. So he has not come to the court, my lord. Not this week, my lord.
May I please, your lordship? My lord, defendant number one has the plaintiff as the appellant before your lordship in a suit for partition and declaration.
Preliminary decree or final decree?
Final decree, your lordship. Final decree. My lord, there is a delay of your lordship. No, the suit is valued at more than 1 lakh.
Why FMET?
My lord,
FAT.
yes, your lordship.
So why FMET is registered?
There's some defects we need to remove, your lordship. That is, we'd be removing it in the course of the day. My lord, father, there's a delay of
It has been
24 days delay also.
464 days delay.
64 days delay.
464.
My lord, initially,
But it has to be registered as FAT.
yes, lordship.
With the advocate on record.
Okay.
The advocate on record. You don't know the distinction between FAT and FMET. Why you have written FMET? When FMET lies? Yes? You don't know.
Fast appeal.
Forward.
It's fast appeal. It is fast appeal for mine.
First appeal means?
First case.
First case.
First case of your career.
Yes.
It's appeal.
Yes. Should appeal.
Defendants are the appellant before your lordship in a suit for partition. And the order
Preliminary decree or final.
in
Or
FMT marriage, order of injunction, identity order of injunction. The difficulty is this lordship I have instructed today that this order of identity injunction has been in the meantime extended twice. The law as on stand today, my lord, I have to my lord. And you need to take an instruction.
Out of this to enable the appellant to take appropriate. Yes.
My lord, appeal against refusal to pass an ad interim order of injunction.
Certified copy.
My lord, we haven't received it yet. My lord, we'd applied it on the reopening day. The order was passed on the last day of court, uploaded for 1 day after the commencement of vacation. So during the course of the week.
Just 1 minute.
My lord. Mm.
Limit. I have not come across that this kind of an injunction can be granted. That on contest, forget about ex parte. Sir, you claim to be the owner of the property.
My lord.
There was a claim by the defendant number one.
My lord. My lord.
Challenging that order of the Tika controller, you went to the land tribunal and the land tribunal held that the property does not comprise the Tika. Fair enough. Then you say that this defendant number one, taking advantage of his situation as a Tika tenant, alleged Tika tenant, created several leases and inducted several sub-leases. They are now running their business. You have filed a suit for recovery of possession. Fair enough on the based upon a title. You wanted an injunction against the defendant number 7 who is already, say,
In possession.
a subtenant,
Yes.
a sublessee,
Yes.
from carrying on the business at the property and also depositing of the sublease rent. Never heard of. I have not come across in my career, both there or here, that this kind of an injunction can be passed.
Lord,
Person is in settled position. Whether it is he is backed with the
correct.
title or
I will.
you cannot disturb the position.
No, absolutely. I am not on possession. I am not on possession at all.
From
Correct.
carrying on the business, which is a fundamental right
Right.
under the constitution.
My lord.
And then a sublessee, you say that you pay a rent, ignoring the defendant number one, who is the original landlord of, say, the defendant number 7.
No.
He's a
Well, the-
landlord.
So far as he is not the landlord. He is not the landlord. I'll tell you. But your lordship will see defendant number
Defendant number 7.
5 and 6.
Whatever. 5 and 6.
Now the question is
Were inducted by whom?
by one.
That's all.
So now the question is that
Defendant number 1.
Yeah.
How can you say that you pay rent?
no, I'll show you. But I'll tell you, lordship. My lord. Once defendant number 1. No, my lord. Kindly appreciate this, my lord. My lord, kindly appreciate this. Your lordship may not be with us, but kindly appreciate this.
Not with us.
No, I can understand that prima facie your lordship is not with us. But my lord, our point is,
I never.
my lord, this situation is unique. That's what I'm trying to indicate to your lordship. This is something unheard of. Defendant number 1 claims to be a Thika tenant. Now, my lord, let's assume for the sake of argument that the Thika controller's order is not there, by which it has held that this is not a Thika land and he is not a Thika tenant. For the time being, your lordship assume that order is not there. So he's a Thika tenant. So in 2011, he grants a 99-year lease to the defendant number 5 and 6 with the option of renewal for the period of 9 as a Thika tenant. My lord, our first question was that there is a specific bar under Thika Tenancy Act for such transfer by way of lease. So that transfer in 2011 to 5 and 6 was void ab initio. Now in 24, despite there being a specific order of a coordinate bench in the previous round when we came from the Land Reforms Tenancy Tribunal before this court, despite that order, a further transfer has been made by 5 and 6 in favor of defendant number 7. So that's why we say that our contention is that 1, 5, 6 as also 7 are all trespassers. So trespassers cannot be allowed to enjoy my property. So I've asked for recovery possession. I will get possession when the suit is finally decreed. Till then we say that trespassers cannot be allowed to enjoy benefits from my property. So you deposit the rent with court. That's all that I'm saying. You have a sublease. So at the interim stage is, we said, my lord, our prayer before the court was direct the defendant who is in possession to deposit the amount that he is paying to the defendant number 5 and 6 in court. This is all. My lord, I will just trouble your lordship with one provision of the Thika Tenancy Act. My lord, kindly once do the Boida.
Not transferable but heritable.
My lord, kindly see the bar. My lord, I am conscious. I am conscious of your lordship's knowledge of the Thika Tenancy Act. My lord, I am conscious of that. My lord, despite that, my lord, I am showing your lordship just one provision. Kindly have a look at it.
The law. In order. So,
Thika.
which provision?
My lord, section 5, subsection 4.
Section 4, you want to read? Read.
No, section 5, subsection 4.
That's why I'm saying
Yes.
section 5, I said.
Yes.
You want to say?
No, my lord, what I'm
What
trying
it
to say,
says,
because
read.
if it is, I am,
Read.
yeah, I will, my lord, what I'm saying is trying to say that it is the specific contention of the first defendant.
What will take care of your appeal?
My lord, I'm telling your lordship, my lord, this is an unusual situation. A person who claims to be a Thika tenant. So if you are a Thika tenant, so then the provisions of the act would apply.
Read the division bench judgment of this court, PIR 1985, Calcutta, Ganesh Trading Company.
Ganesh Trading, 85 Calcutta, Ganesh Trading.
Of Justice Anil Kumar.
Ganesh Trading, the division bench, Calcutta. Well, at subsection 4 of section 5.
Yes, read.
The interests of the Thika tenants holding directly under the state under subsection 1 shall be heritable and shall not be transferable except inter se amongst the heirs and existing co-sharers' interests and spouses or to the prospective heirs with a prior permission of the controller, subject to the provisions of subsection 1 of section 6. So, my lord, here the transfer is to absolutely third parties. So, my lord, this transfer is not recognizable in law, number 1. Number 2.
Justice Praveen Kumar Samanto's judgment.
Well, I am not.
That is what I'm saying. Go and read that judgment where the same point in relation to 81 Act. It is really a replica of a 81 Act.
Right. It is.
That bar was also there in 81 Act.
Yes.
There was a transfer which was effective. And Justice Samanto says that yes, the property right cannot be transferred, but right to collect rent can be transferred.
No, my lord, here the property has been transferred.
So interpret it that this document which is styled as a transfer of the property will be construed as a transfer of right to collect. See, so agreement remain valid, but nature changes.
No, my lord, here is a unusual agreement. It is a 99 years lease. Plus, with the option for a further renewal of 99 years.
For collection of the rent.
No. Kindly have a look at because the Thika tenant, my lord, kindly have a look at this.
I'm just really flowing with the current of your argument. Though I know that what I am saying is absolutely against the law. It is only I am flowing with your argument. Can never be done. A person who is found in settled possession cannot be dispossessed without the
I am not
law.
completely, I couldn't have agreed more.
It is as a trespasser, as a I would say tenant in sufferance, or as a licensee, or in whatever capacity. Unless you get a decree of the court, evict the court, and that also you cannot do it unless you evict defendant number 1, because everybody is claiming right through defendant number 1. Because your case is defendant number 1, 2, defendant number 5 and 6, defendant number 5 and 6 to defendant number 7. So ultimately, their right flows from defendant number 1,
yes,
who is admittedly in second settled possession,
yes,
and claims the Thika tenancy,
yes,
which he could not succeed ultimately. Evict him, they will all go from there. And why the provision of Order 20, Rule 12 is introduced in the Code of Civil Procedure?
My lord, my lord, kindly, may I just answer your lordship first question? Here, my lord, we don't ask for any temporary injunction so far as possession is concerned. My lord, our prayer is.
Ganesh Trading, when I said that you please read that judgment, it relates to a rent.
My lord, this is Ganesh Trading. Justice Anil Shen's judgment. My lord, is 85 Calcutta, page 37.
Mr. Sudhir Das Gupta and Mr. Shaktinath Mukherjee both appeared for his respective parties.
My lord.
Read.
My lord,
What was the case therein?
My lord, this was a
Case was
this was a revisional app.
Lacey, I am
Yes.
telling you, the
My lord.
Lacey suffered a decree.
My lord.
The Lacey inducted several sub-lacees.
My lord.
Then the original owner who was there, he came and wanted to have those sub-lacees. Then the lessee approached the sub-lacees for the rent. Sub-lessee says that you can't because you have suffered a degree. You have no right. I will go to the original owner. I will not pay you. Then the lessees applied for a district, or he filed a distress proceeding before the Presidency Small Clauses Court. That's a very special provision in the Presidency Small Clauses Court Act,
Yes.
where 12 months rent can be attached.
Section 60. Yes.
That was allowed or rejected, I do not know. The matter went to this court. Then they say that you have lost the title. You can't claim anything. The division bench says nothing doing so long they are not physically thrown out. They have every right to do whatever they could do before the decree for possession was passed. Your case is worst. There the decree for possession was passed. Your case is even worse. Till date you have not obtained the decree. So a person who is there in possession, he is an intermeddler. If he intermeddles with the property, then in that event, you can't protect him. You can claim a damages against them, mean property, but you can't claim this right. That's an academic discussion which I am making. That's why I say unheard of, never come across this kind of an injunction.
No, my lord, we are now, my lord, so far as the law relating to possession, enjoyment, my lord, there's a new judgment of the Supreme Court also, your lordship is aware, where Supreme Court has said that there is no bar in law, which was earlier unheard of, regarding the landlord during the pendency of the suit for recovery of possession should or is entitled to occupational charges. This is the new judgment that Supreme Court has said, that you will be entitled to occupational charges at the current rate. That's also surprising. Earlier it was unheard of.
So, you read.
Well, so no,
that was a different case.
No, of course, I am saying.
It does not say in those absolute terms.
No, I am saying our case is equally unique case. A person who claims to be a thika tenant.
He has lost title.
No, I am not on the losing. I am saying that he is a thika tenant. If I say he's a thika tenant, I said he could not have transferred it.
Again, I am saying a person who is put in possession on the basis of a void document.
Correct. I say that his
possession does not mean
no possession. I am not on possession.
Possession becomes obliterated, but his possession is not gone. So long he is there, he is registered.
Well, possibly I have not been able to make myself clear. I am not on possession. I am.
You can't say. Then we will record that you have foregone the right which emanates from the order of the LRTT and treat this defendant number one as a thika tenant. Then I will say the suit is not maintainable. Go.
No, what I am trying to say is, even if he says that he had let out the property,
কোর্ট তো মানে কি লটারি খুলে গেল যেখানে এলআরটি করলো যে ঠিক অ্যাটেন্ডেন্সি বেঁচে গেল, এখন বলছে যে ঠিক অ্যাটেন্ডেন্স মেনে নিচ্ছে।
No, no, what I'm saying, but I'm saying,
দেখো আরে যখন প্রপার্টি ঠিক অ্যাটেন্ডেন্টেড নয় তখন তুমি ঠিক অ্যাটেন্ডেন্সির প্রভিশনটা লাগাবে কিভাবে আমি তাই জানি না, কিভাবে বোঝাবো? When act is not extended to the property, you are taking advantage of the provision of the act. Cannot take it.
so these persons are trespassers. So what I'm saying, so my lord, so
Trespassers cannot be evicted.
I am not on the eviction. I am only on rent, collection of rent. He cannot enjoy rent. That's, I am only limited to rent.
That is the division bench judgment. He will continue to enjoy so long he is there in possession.
So
Read
then,
that judgment.
very well, my lord, then allow me to, my lord, come back. I'll, if I can get an authority. No, my lord, if your lordship has given this, my lord, Ganesh trading, the true term and scope of Ganesh trading we assess before I at
Supreme Court page 620. 68 Supreme Court page 620. AIR 1968 Supreme Court page
620. Your lordship's view is that
one penultimate paragraph of that judgment of the
your lordship's view is that even your lordship's view is that even a trespasser has a right to collect rent.
A person in different possession has a right to do so.
No, so he is admittedly not in settled possession. He never was.
Then he has no title to back it.
Yes.
Back even.
No, we are only on, my lord, today at this stage, we are only on that whether he would be, he is authorized in law to collect rent from the property.
Was there in settled position on the basis of the possession he can enjoy unless his possession is disturbed.
No, possession enjoying, we are not on the possession. We are only on the rent part. That
Then
all we say,
the rule 12 was introduced in CPC for what purpose? For what purpose?
no, that 20 rule.
As the determination of a mean profit.
Yes.
Why? Why it is?
No, no. My lord,
you can claim a mean profit.
of course I can. But what I am saying is,
চিত্তোষ বাবুর জাজমেন্টটাও আছে, ওখানে বললো যে এইভাবে তুমি নিতে পারো না ডাইরেক্টলি এগেইনস্ট এট। এখানে রিসিভার ওখানে চেয়েছিল রিসিভার টু বি অ্যাপয়েন্টেড টু কালেক্ট দ্য রেন্ট ফ্রম দ্য সার্ভিসেস, সেটা বললো একেবারে না, যেটা দেওয়া যাবে। I have forgotten my register.
we are glad that your lordship has. Without the register, there is sufficient coming without the register. So no, with the register, it will be difficult. So will not allow us to consider this justice on ancient judgment.
I gave you the fact.
Yes, yes, yes.
This is what the court says, that so long he is evicted physically, he is entitled to recover rent from his tenant. That is what is the
Very well.
by Calcutta division bench. How can you disrupt it?
No, my lord, if that is the division bench, my lord, then my lord, kindly keep it tomorrow. No, my lord, kindly keep it tomorrow. We'll come back.
The relevant portion. Give me
Okay,
that
okay,
judgment. I will give you
Right.
relevant.
এটা কি বড় করে দাও? কোথায় খুললো? Liquid text কেন খুলছে? It becomes smaller. Liquid text it becomes smaller.
No, liquid test, liquid code, no problem.
No, I'm saying it becomes smaller in one window, it goes into one window. আমায় বলো, I বার করে দিই। Here,
Liquid test কিন্তু খারাপ নয়।
হ্যাঁ? কেন খুলো? বাবা।
Point was subleasing is not done.
Hmm.
Stop it from this. Even but observe that there is an ample substance in this convention and circuit that appears to us to be a second principle. The whole section 16 of the ordinance Act, that this is excluding the capital in the second is not precluded from being loss of capital subsequently as a result of eviction by taxing the party.
আমাকে বলো না ওটা খুঁজে পাচ্ছি না কেন কি আছে দাঁড়া 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 দাঁড়া
Cannot
এটা
constitute
আছে
eviction by taxing the
দেখি আছে হ্যাঁ
in order to constitute such eviction, there must be actual disposition. Must be disposition, maybe by the use of symbolic position, with the consequence of execution position. The symbolic right on our attention to the following observation.
I doubt it. No, invalid. সব দিচ্ছে আজে বাজে কি যা তা বলছে এরকম কোনো এই নেই BMW না না 2023 কত
সেখানে বলবো যে নো মুখ্য বলবো যে my right is there unless I am
at the rate
yes read paragraph 5 and 6 straight away answer is very clear.
Password detail.
Paragraph 5 is a point which is involved in your case. Paragraph 5. Read the point.
The short point that arises for our consideration, therefore, is as to whether the order for eviction has passed against the lessee by itself determines the lease's title to realize rent from the sublessee.
This is what the same point. Whether it gets, that was a better case than you.
Yes, yes. And
it entitles the lessee to collect rent.
That's
He's a trespasser. Says no. So long he
no, I am on a instrument which is, we say, void ab initio. That instrument is otherwise hid by the provisions of subsection 4 of section 5, because that was created at the time when he claimed to be a thicca tenant. So the instrument by which he transferred his, no, I don't know. I don't want. I don't want.
I will.
No, I don't want. I don't want. I'm trying.
I will take into account that section 5(4), and now let us decide that what does it mean.
No, then I have to, then Manoj, based on this, I have to get ready and come back with some more judgments to deal with this.
No.
But there are some other points we also have. But kindly allow us to come back tomorrow. Kindly allow us to come back tomorrow, because the situation will not change. I have suffered there is refusal of an ex parte order, so the defendants cannot suffer any prejudice. So if any sufferance, it's the plaintiff. It is my suit. So let me come back tomorrow if I can convince your lordship, which I can understand it's going to be difficult, but allow us one attempt.
Obviously impossible.
No, it appears impossible. But my lord, kindly give us one opportunity. I'll come back tomorrow if we can find any authority which says otherwise. No, I mean, I am on that instrument part. Lessee's right to collect rent post decree.
Ponder upon the situation that the moment you take shelter under the West Bengal,
I can understand
the acquisition regulation,
then
you will kill your own case.
Correct. No, we are not there.
If you take, we will say so. And the moment we make certain observation, we do not know how it will be reacted.
I can understand your lordship is saying that once you take shelter of 5(4), then you are accepting him as a thicca tenant. Or you are at least
abandoning whatever the right is created by virtue of LRTT.
Understood.
Don't you understand?
I can understand that. I can understand. Right.
Which is outside the purview of the West Bengal Presidency Act. And then Transfer of Property Act is sued under upon notice under section 106 is filed. And then you say the provision of the West Bengal Proceedings Act. You know what is the dangerous
I know.
consequences for the landlord?
No. So that is why we say,
So how can you take shelter under those provisions when that act is not extended to your property?
so below those instruments, very well, I've understood what has fallen from your lordship.
Property. If somebody has given a lease of 99 years
Hmm.
and then say, look, ticker tenancy, there is a bar. You will never permit your property to be a ticker tenanted property at any point.
Understood.
You are taking a shelter under a law which really demolishes your
Correct. Prejudices my own interest. Allow us to come back tomorrow, my lord. Killing.
Tomorrow,
Well, if there is anything we find, we'll come back tomorrow. If you then that same order will suffer. We'll suffer the same order tomorrow. No, my lord, kindly don't do that, my lord. We'll come back tomorrow and suffer the same order.
Dictating the order.
Well, kindly don't do that.
We sign tomorrow.
Kindly don't do that, my lord. We'll come back tomorrow. Lordship will dictate and sign. No, I will appreciate, we will understand, appreciate, we'll see. I can understand what has fallen from your lordship.
You can't prevent it. You can ask for an injunction not to create any further interest in the property. I can understand to that extent. But not to pay rent, deposit the rent, I don't think so that you can. For that, you can claim for a mean profit. That is what I said. Order 22.
No, I can understand.
The moment you get an eviction,
Correct.
the wrongful occupation in the property, you can get it.
An addition, alteration, further alienation, this can be prevented. Very well. I will come back to that tomorrow.
No. First matter has to be mentioned. 10:30. Yes. Yes, I borrow a benefit of the internet destructive. Where's the ticket? Declaration. It's not a ticket. You voice a second. तो टाइम बोलছে তো কোথায় deficit কি আছে 24,000 In the event the deficit got fees is not deposited,
I 55, my lords, I am praying for an accommodation today, my lord. My lords, the illness of the advocate on record. And further, my lords, it is appearing under Order 41, Rule 11, but a restoration application is pending, my lord.
পিছনে দাওনি কেন ডিসমিস হয়ে রয়েছে
My lord, I am appealing for the my lord. Plaintiff appellant before your lordship. My lord, during pendency of the appeal, my lord.
So there is a substitution. Can you dispose the principal on steel to the appropriate order is
Move to substitution and appropriate order. Substitution. Substitution.
It appears that the appellant number 1 has expired during the pendency of the instant appeal. Unless the said application is disposed of, the matter cannot be taken up under order 41. Liberty is granted. Let the matter go out of it. Liberty is granted to the appellant to bring for
application. I have heard the appellant with Mr. Zakir Hossain, but there are two defects. So far, I came to know from London friend Milord that one defect is regarding the valuation. In the suit, it was valued at rupees 49, but in the degree of the appellate court, it has been stated that the appeal valued at rupees 100. And another defect is, Milord, the judgment of reversal. But in the first heading, it has been stated as a judgment of affirmation.
Please correct.
And also kindly
valuation,
Milord,
is a 49 rupees.
49 rupees in the suit. But appeal court in the degree, it has been stated in the degree, appeal valued at rupees 100.
Anyhow, you have paid the higher court fee.
No, we have paid the court fees according to suit value. And that is perhaps it's a stay. Stamp duty is staying. আচ্ছা
আমি তো ভোকা ফাইল করেছি, আমি ওর কাছে কপি চেয়েছিলাম, দিল না আমার।
সেটা কোর্টের ডিরেকশন ছাড়া দেবে কি করে? অর্ডার
ভোকা ফাইল করেছিল।
There are two suits.
There are
One appeal, one suit, two appeals by both the parties. My appeal, the appeal
before your
appeal preferred by the plaintiff succeed.
That you are challenging an order in title appeal number 12.
Yes, but not challenged.
Furnishing the certified copy of the decree passed in title appeal number 16.
16 I can't read.
The appeal which I succeed, not challenged.
But actually,
not challenged.
I have filed this appeal challenging the degree, judgment and degree in title appeal number 12 of 2026, 2016.
And what about the title appeal number 16?
Title appeal number 16, that's the call.
That
that even Lordship kindly give some time so that I can.
Both the appeals were disposed of by a common judgment.
No.
Common.
Separate judgment.
Separate.
No.
Separate judgment.
Separate judgment. That is why I have challenged the title appeal number 12 of.
What is the suit for?
Suit for declaration. And originally, Bellot, suit property belonged to the father of the present appellant. After the demise of the father, Bellot, it was devolved upon his legal heirs. That is about 12%. But they are saying that all the other person made a gift in favor of the present respondent,
including you.
Yes, but I am challenging the same because I never put any signature in the gift.
So the deed was produced.
Huh? Yes.
The deed was produced.
No, deed. Well, I have a deed, copy of the deed, but I am denying it's my signature.
The trial court, the deed was produced on the basis thereof they claimed their right.
Yes, yes.
Deed was produced.
Yes.
Original deed.
Yes.
Did you apply for a handwriting expert?
No, but that is my mistake.
No,
But that
you
is
did
my
not.
mistake.
Mistake.
That is my
It's
mistake.
It's a fatal. It's not a mistake. It is a fatal. If you
that your lordship
saying it is not my signature will not do because it is a registered document.
It's a registered document.
If a registered document carries a presumption of its due execution, that's a very fundamental law we learned. A registered document carries a presumption of due execution. Due execution means that every party to the document have executed.
But I have.
If you say that no, somebody impersonating yourself, somebody.
Yes, that is my case.
Then will you not take steps to tally the signature with your signature?
Well, it ought to be. But what happened, my lord? I am filing the suit on the basis of the section 14(1) of the Hindu Succession Act.
What?
14(1).
What 14(1)?
But I have a right because I have already get the
14(1) what right? 14(1) what it says? But wasting of a right. What? The female's right.
Right? Because I have received my portion from my father. After the demise of my father, I have got the property. I am not asking any entire property. I am asking only my portion.
My lord, fact is otherwise, my lord.
দাঁড়াও না ভাই, তুমি বলবে অর্ডার 41 তোমার কোনো রাইট আছে নাকি?
I have cautioned you on the earlier occasion also. When a second appeal is listed, the respondent has no right of audience unless the appeal is admitted. Please do not interfere. When we are putting a question, let us. When we want you to put answer, then you give answer. Bad habit of interfering. Don't ignite the situation. I am not that bold as that of Justice N.K. Mitro. If the respondent interferes at the time of admission, the order would have been admit. I am not that bold.
And anyway, that point was not raised.
Just lies on you to prove it.
That's right. That's right.
Simple denial will not do. You'll have to. One who asserts that this is not my signature.
Yes.
The onus lies on him to prove it.
Yes, yes.
I believe section 100 or 102 of the Evidence Act. New, I do not know. New, I do not know.
No.
Bharatiya Sakha Adhiniyam, I do not know. I know the Indian Evidence Act.
But I am admitting that that point was not raised. Even that challenge was not made.
If that being the position, how you can say that this is the post document?
But a trial court gave the degree in my favor.
I do not know what is the reason, but the appellate court has said that this was wrong. That's why I asked you a question. A document is staring at your face where you are one of the executed.
Yes, one of the executed, as per their claim.
Say that I never executed it, then the onus lies on you to prove it, that you have not never executed. Signature, you have to find out from the expert.
Handwriting expert.
If you have not done, then nothing.
ওইটাই তো তোমার লাইফ ইন্টারেস্টিং ব্যাপার, তোমার যে মেন জিনিসটাই তো তোমার।
You can't improve the case, sir. What your counterpart in the trial court did?
That I don't know, Milord. In trial court, there is another lawyer, Milord.
Could have applied before the appellate court also.
Yes, that has not been made. That has not been made.
Then,
but that I admit, Milord.
Then what can be done, sir? What more? You can't, that case, that fact, how can you prove it?
Well,
Has to be, otherwise.
one liberty, may I ask to challenge the same before the.
No, is not admitted.
Yes,
Cannot
that
admit.
cannot be admitted. You know.
That's it. Yes.
Judgment reserved.
Yes, my brother will.
Yes, yes. I'm
Not
grateful.
judgment, we will deliver.
I'm grateful.
For orders, it will come. Don't-
I'm grateful.
That's all.
For the appellant. There are defects, two defects.
Do not
One,
interfere. Don't do that. Not a very good taste. Everybody, that's a very healthy system.
Yes.
He is getting an opportunity. You will get an opportunity. When your turn will come, you will definitely. But intervening is never appreciated. Never appreciated.
I'm sorry, one.
not the defects. I understand not the one defect. Learned, it was file was sent to the learned court below for correction of the
That has
date.
been removed, I believe.
That has been
I find everything has been removed.
although it is noted defective, not as such. This is
No, there is
judgment.
no defect. Stamp reporter says all defects are removed. Who are you in the trial court?
Lord, this is judgment of affirmation, Lord.
Who are you in the trial court?
Plaintiff.
Plaintiff.
I am the plaintiff.
It's a judgment of affirmance. Since your suit is dismissed by
Suit was
trial court
dismissed.
affirmed by
The appeal paper, appeal was also dismissed.
What is the nature of the suit?
The suit was the eviction of a licensing, Lord.
You filed a suit for eviction of a license.
See,
that is dismissed.
Suit was
What ground?
on the ground that the defendant became the prospective buyer in respect of the property. Since there was an agreement with the developer, in the meantime, the landlord handed over the property to for joint venture, Lord, and there was an agreement signed by the developer as well as the defendant, where the plaintiff also signed. So court held that since he is a prospective buyer, he cannot be evicted on the ground of licensing. That was the position, Lord.
No. Why you went and filed a suit when you have already handed over to a developer?
Lord,
Means the
for
developer might
6
have taken a
months,
position.
the defendant was known to me previously, Lord. He requested me for 6 months. I have handed over I given the property without any reason, Lord, for 6 months. Since he didn't vacate the property, Lord, after 6 months, I served the notice. And thereafter, Lord, I filed the suit. Since
No, you have already given it to a developer.
Subsequently.
The suit.
Previously, it was handed over to the developer. Before after the building was constructed, he entered into the premises.
When the agreement was
2017.
Means prior to the license is given.
Yes.
So
subsequent.
So he was in possession prior to your creation of a license.
But, also.
Otherwise, why agreement?
Agreement speaks about the agreement between the defendant and the developer. That is by 2020, not after the building was constructed, not the exhibit A, not.
Was he inducted? Where is the case? Just 1 minute. Let us go through the chapter. It is a subject property is a flat or a shop in the ground floor.
No, flat. One, one room plus adjoining PV bath.
মাথার মধ্যে বুদ্ধি নেই রিপোর্টটা কিছু করা যায় না।
So, my dear,
What is this agreement of 2019 or 15?
the development agreement with the developer by the plaintiff lord is the 2019,
Agreement by
17.
virtue whereof this agreement where he has agreed to purchase.
That is with the
30th of
developer.
March 2019.
Unregistered agreement.
Exhibit A.
Exhibit A, 30th March 2019. Lord, it was between the developer.
Developer, you and the defendant. I am asking.
I am an old man. I was asked to sign. Developer asked me to sign. I signed it up. Is it admitted position?
Please tell me.
But it was not registered
Agreement
document.
is Exhibit A.
My lord.
Correct. Is a registered document?
Not registered. Simply.
From where do I get it? Anything from the judgment you can show that the court has recorded not a registered document.
That will not
Registration Act also.
That was the argument advanced. Not I do not know.
What argument?
But that is admitted position. I will have to go through it.
So 68 of production eligibility. Performance, the balance total, the transference, titles to disturb this.
সেটা বলছি না আমরা আর্গুমেন্ট করেছিলাম যেটা আনরেজিস্টার্ড ডকুমেন্ট কোথাও ডিসকাস করেছে
এখানে
প্রশ্ন simply said that an agreement has been entered into by and between the developer and
Tell me it is a registered or not a registered.
not registered.
Tell us.
Not registered.
Then why you are not taking a very vital point?
Not in the trial court judgment, it is only says.
Sorry? Legal point you have not taken. Very important and vital point in your favor and you have not taken. Is a bench who has to tell you that what good point you have.
That's true.
Where is the Registration Act? Can you find out from your mobile and or a
Registration Act
iPad? Have you noticed? Both the trial court and appellate court has said that he has a protected possession under section 53 capital A on the basis of a part performance of an agreement. Agreement was entered into in 2019. There is an amendment which is brought under the Registration Act, section 17(1)(a), which says that unless the document is registered, the protection under section 53A is not available. So if the 53A protection is not available, then how can he give a protection? You do not know. And you are not taking that point. It is the judge who has to tell you.
No, I was just started my.
Look at section 17, 1 capital A. When only thing is when this amendment is brought, I just wanted to know.
September 2001.
2001, 24 September.
That is what I'm saying, 2001. What it says, read
My lord.
till not reading.
No, no.
No.
Yes, yes. The documents containing contracts to transfer the একটু বড় না করলে হবে না তো এত ছোট পড়তে পারবো না
করতে পারছি। It print out of officer
My lord, to transfer for consideration any immovable property for the purpose of section 53A of the Transfer of Property Act 1882 shall be registered if they have been executed on or after the commencement of the registration and other related laws, Amendment Act 2001, and if such documents are not registered on or after such commencement, then they shall have no effect for the purpose of section 53A. That is clear. Thank you.
That is a vital point, only point. You have not really worked. Mr. Panchal, you have not worked on the brief.
Housing is protection of
রেজিস্ট্রেশন বলে দিই জানি তো বলবে না জানি না
I have taken in the grounds itself.
No, we have seen the ground number 7 or 8.
Ground number 4 first.
We have not said that it is not registered.
Unregistered agreement. I have stated.
Then why you are not arguing? This is the only point.
Yes.
Document containing the contracts to transfer of consideration and property for the purpose of 53A shall be registered if they have been executed or after the commencement of this. If such documents are not registered on or before such commencement, then that shall have no effect for the purpose of 53. So, are they transfer? A transfer of property to the contracts which transfer of consideration and property signed by the or on behalf of it has any property constitute the transfer can be ascertained to the transferring as in part performance of the contract taken possession of the property of the party of the position part performance of some activity for the person was then constantly instrument there is an instrument that the transfer has not been completed is going to be the transferor or a shall not shall be debarred from enforcing against the transferring of persons any right respect of the property of which the transfer is taken under condition. So it a protected position. The appeal shall be heard on the following substitute. Yes.
Okay,
Mr.
বইটা আমাদের-
Patel, you are not,
because of I should
so
not
you did not read the brief properly.
because of a brief illness, not in the meantime I could not prepare myself, not that's the reason, Lord. I'm sorry, my Lord, I could not.
Call the next.
Yes.
Lordship, in this matter, Mr. Probal Mukherjee is appearing and he has been engaged by the legal aid authority services. But he has not come today and I have to give some documents to the senior counsel. So kindly make it not this week.
Why he has not come?
I don't know. I have got the information that he has not come. Let-
Should I appear for the respondent? The suit for plaintiff is the appellant before your lordship.
Judgment of affirmance.
Judgment of affirmance, decree for declaration, hearing title, and for cancellation, not cancellation, declaring that the deed executed in favor of the defendant is void.
What is the nature of the deed?
There is a lease executed for 999 years.
999 years.
999 years. And the original property belongs
One
to
year short of 1,000 years. Yes.
now the case. The plaintiff is that the original owner of the property was Ghosh to Bihari.
What?
Ghosh to Bihari. One Ghosh to Bihari. He has two wives. Both were issueless. Accordingly, they adopted
Both were issueless.
Yes. They adopted the plaintiff as an adopted son. In the meantime, Ghosh to Bihari executed an orphanama. According to us, it is an orphanama. An orphanama. According to them, it is a transfer in favor of the second wife. The orphanama, he has
Being an adopted son is thrown out.
No, it is orphanama. That is what, Malat, I am to submit. That the orphanama for the it is dedicated to the deity with the right to the second wife to perform all the pujas and all other things with a specific rider not to transfer or alienate. I'll satisfy Lordship on that point. The plaintiff has failed to prove the consent of the other mother on the basis of a document executed by first wife in favor of the second wife, where the first wife is saying, after death of her husband, I and you are the only legal heirs. Childless, and we are only the legal heirs. On the basis of such statement made, it was held that there is no consent on the part of the wife regarding adoption. On the contrary, we have produced.
The adoption was in dispute.
Adoption was in dispute. Now, my lord, on that score, my lord, the court will have held that there is no valid adoption because there is no consent on the part of the wife taken.
There are two persons. One is an adoptive father and an adoptive mother. There cannot be adoptive mothers. It will be in a singular form. If the second wife is considered to be your adoptive mother, so the consent of first wife.
There is the first wife declaration regarding the childless, and we are only the legal heirs of our husband. The trial court assumes that there is no consent on the part of the wife at the time of adoption. But on the contrary,
Where the consent is required?
In view of the Maintenance Act, if there is a wife, my lord, her consent is required. It is held by the trial court, my lord.
No, wife means what? There is a Hindu. Is a Hindu or the person of God?
Hindu. My lord is saying about the
ওই বইগুলো আনতে হবে। আমি তো আমার একটা প্রিন্টার দরকার ছিল যে বইগুলো ব্যাগে রাখা আছে। Yeah. Yeah, Lord, kindly turn to the relevant portion, my lord. It has been also been quoted over here also.
No, no, section has been quoted.
The yes, the judgment has been quoted on basis of which it came.
Section.
Lord, I kindly pardon, I have only one copy.
Yes.
Section 7.
7.
Section 7, the proviso.
Yes.
Therefore, these are the things you get to prove. My lord, on the basis of which, my lord, I am drawing lord's attention. So for the findings of the learned trial court regarding the adoption, only this is, if I can prove the adoption, then I can come forward regarding the Orphanum and other things.
Orphanum, there is any reference?
No, no, at that point of time,
Your existence.
no, at that point of time, no.
It was
After,
prior to your
prior
adoption
to,
or-
prior to. If your lordship can turn to issue number 3 of the trial court judgment, that is the internal page 10 of দুটো বিষয়। After second, there's no issue. My lord, can you turn to page 70, page 10 of the trial court judgment, issue number 3. My lord is. Can it consider the cross-examination of PW1 being the appellant herein? That is the next page from the top. There are relatives like such and such who were present at the time of my adoption, and many others were also present, but they are not living. If required, I'll bring the above named person to dispose of the said named person.
Please tell me that this second marriage was solemnized prior to 1956 or prior?
56, prior to 56.
Adoption was prior to 56 or after?
It post 56. Post 56.
Yes.
Post 56. Post 56. Date of adoption. দেখে নিব।
Lord, 64.
64.
Your lordship would find that at second page, my lord.
It's 64 because Goshtuberi died in the year 66.
Yes.
Goshtuberi died 66. Adoption was in the year 64. And the deed was Devottar was done prior to that. So my learned friend is actually Devottar. Now, well, can you consider?
I'm not audible.
You are not audible. Page 10 of page 17, my lord, I am drawing lord's attention so for that portion. The ceremony was there and some persons were present. It was specifically stated by the PW2 who was present at that ceremony. First, the priest Sri Chandra made puja, then he performed home, and then he asked to the natural parents of Shamir Gorai, the plaintiff, to hand over the said Shamir Gorai.
Did you produce any person
Document
who was present at the time of Datta home or whatever?
Yes, the person PW2. PW2 who was present.
He was present at the
Yes.
time when the adoption was taken.
Yes. It was held, my lord.
The
That is
document. What was your age at the time of?
7 or 8 years. 7 or 8 years.
What the school certificate say?
Yes. There are school certificates. Initially, it was in the name of my biological father because it is 8 years. But there's
All other documents are there by voter cards and other cards.
10, 11, 12.
No, school certificates are there and
starting up to 10.
Yes, and not only that, after that I have my passbook along with my mother as a son and mother. I produce all those documents. It is not that the only 2 documents were there where my biological mother, father's name was there.
Who is
He is
who
transferee from the second wife, 999 years Tracy.
Oh.
He is now trying to disturb my position. That is why, my lord, I filed the suit. Now, my lord, the findings for disbelieving my case of adoption, my lord, only on the basis, my lord, that portion.
Second mother or whatever, the adopted mother is alive.
No.
It's Ampola, she expired in 2007.
2007. Long
2007.
And discuss. Furthermore, in the documents marked Exhibit ECs produced by the defendant, the certificate issued by the License Department of Asansol Corporation relating to business of the plaintiff varying from year 1984 to 1990, it appears the name of Father Shomir Gorai, is recorded Rishikesh Gorai, the natural father of the plaintiff. The said document raised questions to the mind of the court as to why should plaintiff mention the name of the father Rishikesh Gorai with the Trade License Department or Asansol Municipal Corporation. Though the trade license is not a document constituting valid adoption, still the plaintiff has not given the evidence in respect of such recording in spite of getting opportunity to adduce evidence or recall or complete the evidence by the defendant.
You gave evidence. You did not adduce evidence.
Yes, PW. No, after they produced that document from the municipal, I did not adduce to clarify that document. Why? That is the, as discussed earlier, the says judgment such and such, the normal rule. My lord, this is the finding which comes. The normal rules which govern civil proceedings is the fact that the said to be established in the proof by preponderance of probabilities. This is for the reason under Evidence Act, Section 3, a fact is to be proved when the court either believes it to be exist or consider its existence to probable. And a prudent man under the circumstances, the particular case, to act upon the supposition that it exists. The belief regarding the existence of a fact that thus be found on a balance of probabilities. A prudent man faced with the conflicting probabilities concerning the fact situation will act on the supposition that the fact exists. If on weighing the various probabilities he finds that the preponderance in favor of the existence of a particular fact. As a prudent man, the court applies this test for finding whether the fact in issue can be said to be proved. In the present case, plaintiff is not able to rebut the presumption which arose in favor of fact that no consent by the wife of Gostovier in alleged procedure of adoption. As discussed, consent of the wife is precondition to constitute a valid adoption. Thus, upon weighing the probabilities of this court does not find the preponderance of existing in favor of the fact of the issue of the plaintiff in adopted son Gostovier. So this is the specific finding of the trial court for the purpose of holding there is no valid adoption. On the contrary, the documents which
for the scope of the suit.
For declaration of title and permanent injunction, I have for
what as adopted son.
As adopted son, and for declaring that the deed is void because it's an orphanoma. This is a property dedicated to the deity with a rider that this property cannot be sold or transfer. Now, my Kali, consider the documents they have relied upon that was considered, and the documents which I have filed showing that my mother's name is there along with me, the post office cards and other things, those are not been considered at all. Whether this document can be
The first
my mother's name,
first mother or second?
Second mother. Second mother. That your lordship will find. This is the finding of the trial court. And my lord, Kali, consider the appeals court judgment, a 3 pages judgment, my lord, page 14 of the appeals court judgment.
3 pages judgment.
Practical 3 pages judgment. Page 14, 15, and 16. The appellant asserts himself to be the, and my lord got it, page 14, internal page 14 of the appeals court judgment. Some goes to vary. Now, if that the fact of adoption is proved, then the other facts asserts by the appellant plaintiff will be taken into consideration. Sinking the statute Hindu Adoption and Maintenance Act, the condition precedent to be processed of Hindu adoption reveals the consent of the wife and the proof of the ceremony of actual giving and taking adoption of Datta home as mandatory. Herein, while perusing the LCR, neither I find any proof of ceremony of adoption. Pause here for a moment and my lord kindly consider the evidence of PW2, who himself said, yes, I was present at the time of occasion, and it was the biological father handed over the boy to the adopted father. It was a specific.
Adoptive father or adoptive parent?
It was held by the adoptive father. It should be in that question, how the question was put forward ballot on the basis of that ballot. So ceremony was held. It is not a case that the ceremony was held, but not in accordance with law. The appellate court procedure, there is no ceremony.
How the ceremony was held?
Yes. এটা কিসের কোনটা ইয়েতে সেটা এক্সিবিট হয়েছিল মানে exhibit 3 the deed was there, deed of adoption at that point, right? Though it was not mandatory, no, it is not necessary, deed of adoption, but it was held by sometimes while it appears it was there. Exhibit 5 unregistered. Who is the Pandit has
exhibit how?
Exhibit 3, my lord, without objection, my lord. It appears, my lord, for the Charles Court judgment, my lord, the exhibit marking.
Contains the signature of both the adoptive father and the adoptive mother.
That, my lord, I just. আছে ডিপটা আছে পিএসসি কপিটা দেখি আমার কাছে দেয়নি পিএসসি কপিটা দেখি আমি দেখে নি আমি দেখ রেজিস্টার ডিপ বলছি আমি একবার দেখে নি এক্সিবিট 3 দেখ তো না 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 এক্সিবিট 3 তো 56 এ না না এই যে এখানে কি লিখছে Pandit has been confirmed the deed mark exhibit 3 exhibit 3 mark 5 in the deed লিখেছে কি জানেন exhibit 3 mark 5 কি বলতে চাইছে আমি সেটাই নিজে বুঝতে পারছি না আমি সেই জন্য যশোরকে বলতে পারছি না যে আমি পুরোটা এখানে নেই exhibit 3 is 56 did না আমি এটা হচ্ছে অর্পণ নাম এটা অর্পণ নাম এর অর্পণ মানে না ফাইন
এই দুটো ডিট তো তোমার প্রথম দুটো তো হচ্ছে লিজ ডিট তারপরেরটা দেবত্ব মানে অর্পণনামা তারপরে গুলো তো প্যান কার্ড ভোটার
কার্ড আমি সেটাই দেখলাম যে চেক করে নেবে কিন্তু এখানে লেখা আছে সেই maybe excuse my lord, though there is written, but it is not reflected from the order that there is such deed has been at all produced. So I'm not placing that portion, my lord. That deed, though it is.
No, I wanted to look at the deed.
That is not my lord, but it is
no such deed.
That is the deed of some others.
Two deeds are of Milord lease deed, and the third one is Milord Orponnam. These are the three deeds produced by the plaintiff.
So that deed was not there, but it is recorded in such a manner it looks like a deed. But the PW2 have adduced evidence saying this ceremony was held and it was held in such a manner. The appellate court procedure, there is no ceremony. Now, my lord, what is that? I find that one deed of gift being number 6090 for the year 1966, executed by Shorola Bala, which is produced from their side in favor of Parvati Bala. That facilitating the fact is that therein the donor Shorola Bala declared both herself and Parvati Bala as childless and their husband died issueless, leaving behind herself and Parvati Bala his only legal heirs and successors. These are these.
You might be not taking care of your mothers.
This is the only statement on the basis of which the court of appeal will proceeded as held. There is no consent on the part of the wife for the purpose of adoption, so this adoption is invalid. On the contrary, the documents which are produced where my father's name and also my mother's names were there, that not been considered. Those are the documents which are, my lord, marked as.
Where you are living?
Same house. The voter identity card, PAN card, passbook. At that point of time, 1970, where I, along with my mother, is the name holder, showing there I am the son. Those documents were there. There is nothing on the part of the courts below.
Mother means the donor of that executive.
Parvati. Parvati. Doni.
You instituted the suit after the death of the mother.
Yes. Now, only the deed pursuant to which is the orphanama there. Only two things I want to read from the orphanama, the portion which is very necessary for me, my lord. আমি শ্রী শ্রী দক্ষিণা কালী মাতার দৈনন্দিন পূজা নির্বাহ করিতেছি, এতক্ষণে আমি আর কোনো বড় বড় ব্যবসাদি করি না এবং অধিকাংশ সময় শ্রী শ্রী ঈশ্বর চিন্তায় দিন অতিবাহিত করিতে থাকি। আমার প্রথম পত্নী শ্রীমতী সরলাবালা দাসী বর্তমানে বিষয় বুঝি বিহীনা এবং সংসার চালাইতে তার কোনো ক্ষমতা নাই। আমার দ্বিতীয় পত্নী তুমি শ্রীমতী পার্বতী দাসী ওরফে পার্বতীবালা দাসী আমার সংসারে যাবতীয় কর্ম সুষ্ঠুভাবে পরিচালনা করিয়া আসিতেছ এবং আমার প্রতি দক্ষিণা কালী মাতার
Father has executed.
Yes.
When?
That was executed in the 1956.
That you were not born.
That is why.
You were not there.
So, and there is a recital that this property will not be transferred in this deed. The property which has been mentioned in this deed was directed not to be transferred. Konorakum? তোমার সর্বদমে চিরকাল সেবা পূজা মহোৎসবে যুক্ত থাকবে, নিমিত্ত সেবা নির্বাহ থাকবে উপযুক্ত ব্যক্তিকে আসানসোল স্থিত রামকৃষ্ণ মিশনে তদানীতি স্বামীজি আমার শহীদ অমূল্য বন্দাকে নিয়ে উপযুক্ত ব্যক্তিকে আমার ওই সকল দেবকীর্তি পরিচালনায় ভার দিতে পারিবেন এবং তুমি তদন্ত ব্যক্তিকে মনোনয়ন করিবেন। So it is practically Devottar property. Dedication was there. Orphanama was executed. Deed was executed 999 years lease in favor of my landed friend's client. Now, my lord, I am claiming to be the adopted son which was done in the 1962. My lord, the documents which has not been considered at all. The trial got proceeded in one way. The appeals court, on the basis of that finding, recording in the deed, held that there is no valid consent of the part of the wife. এটা আলাদা ওটা না। And the basic restriction was that তপোলিত সম্পত্তি সকল তুমি my ওয়ারিশগণ,
Deed of gift.
the deed of gift. The orphanama deed or yes, this is the legible
Deed of gift. One wife to another.
one by western. ইয়েটা বার কর, deed of gift যেটা আছে এই ইয়েতে দিল 1966 এর দলিলটা 1955 পঁচিশ। আছে তোর কাছে দলিলটা আছে?
বের করলো
না না বের করলো না, ওটা জাজমেন্টে কোট করা আছে, ওইখান থেকে বললাম আমি। আমার কাছে কপি আছে, কপি copy is not with me, my lord. That copy is not with me. The lease is there and corporate number.
Come ready.
Yes, my lord. এইখানে একটা পেয়ে তারপরে এটা খুলে দেখি ইংলিশ তারপরে ডিভিউটি পার্বতীবেলা করাই deed of the deed, well, that deed is not with me. That deed is not.
To just look at the content of that. Do you have the copy of that? Bring it tomorrow. Give it.
সবটা দেওয়া আমাকে মামলাটা যেটা আরে এটা ডিড অফ অর্পণ মানে যেটা আরেকটা জন বউ আরেকজনকে দিয়েছে সেই ডিডটা কোথায়
ইম্পর্টেন্সটাই বুঝতে পারছি
নট ম্যারিড দ্যাটস আই কুড নট আন্ডারস্ট্যান্ড দ্য ইম্পর্টেন্স অফ ইউ ডিড
62.
This matter, Mr. Supratim Dhar is appearing on behalf of the appellant. Mr. Supratim Dhar is appearing on behalf of the appellant, my lord. My lord, I have to sit with him, my lord, in today's evening, my lord. Kindly keep it to tomorrow, my lord.
Not today.
Time for the 37.
What is the defects?
No, sorry, I mean 66.
My lord, I beg to appear virtually for the appellants in item number 63. My lord, this is a second appeal challenging the order of sorry, my lord. My lord, there seem to be some defect. Certain certified copies could not be filed.
It appears from the report.
Appearing for the appellant, my lord, it is defective. The fact that in the order sheet of the learned appellate court below, lordship, the date has been specified in a mistaken manner, your lordship. It has to be rectified and praying for an accommodation, your lordship.
These are all the official problems that we will take care of that. It does not. Anyhow, yes, what is the matter about? Forget about the defect.
First time praying
We
for
are
an accommodation.
ignoring the defect.
Lordship, I'm led by Advocate Maiti in this matter, your lordship. On the ground of the defect, your lordship, I was
What,
asked to
Mr.
pray for an
Maiti?
adjournment. Lordship, I was asked to pray for an adjournment on the ground of the defect, your lordship. Kindly grant me an accommodation for a day, your lordship.
Which Mr. Maiti?
Advocate Mukteshwar Maiti, your lordship. For a day, your lordship, not today, just for the day, lordship. Lordship, initially an order was passed, a suit was filed for injunction and declaration, your lordship.
So then you are ready, you argue. Yes.
Lordship, I'm only aware of the facts. Your Lordship, kindly grant me an accommodation, Lordship.
That is what is required.
Lordship, kindly, one day, Lordship.
Why the suit is dismissed by the trial court?
Lordship, the respondents had filed the suit for declaration injunction, Your Lordship. They had no title over the particular plot, Your Lordship, because of which the learned trial court had dismissed it. Subsequently, an appeal was filed before the second appellate court, who had partly allowed their prayer, Your Lordship, against which we have filed the second appeal.
So you were declared to be the co-sharer
Lordship, before
by the trial court.
the trial court had dismissed it, the suit of the respondents. It was only the second appellate court,
Declaring
but
that you are also co-sharer.
Lordship.
Appellate court has reversed in part.
Lordship.
What it says. Joint position has been given.
Lordship, on hegemony ground. Lordship, there are other grounds as well, Your Lordship. Kindly grant me an accommodation, Lordship. There are other grounds
Come
as well.
tomorrow.
Gratefully.
Call the next.
65. 65, Your Lordship. I'm praying for accommodation, Your Lordship. The brief is not here, Your Lordship.
66.
66.
Yes.
Document of affirmation, I am the defendant in the suit. Suit for eviction of license.
Both the courts. What was your defense?
I defense in the two before filing the suit, two notices were sent. Consecutive notice. Two notices were sent by the licensor. In the second notice, I was declared as tenant. And in course of cross-examination, he also admitted that defendant was inducted as tenant. So, my lord, instead of filing this suit, the plaintiff could have filed the suit for, my lord, eviction of tenant, my lord, under the Premises Tenancy Act.
Where is 450 rupees? In the report of the additional call the next 67.
67.
68.
68.
What is the defect?
There are three defects, my lord, out of which one has been cured. The one defect has Lord, can see the number.
Monday. Monday. No, বলছি 1 week বুধবার বলছি আজকে যেটা হিসাব করলে বুধবার না মানডে রাখতে বললো তো হ্যাঁ ও লিখবে তো আমরা লিখবো
Trial court that has been filed
কত তারিখে আসবে বলে
regarding the
সোমবার 11 তারিখ
here certain fact is required to be file an application to that defense. Regarding three, my lord, the wrong date in the
Where is the decree of the trial court?
my lord, I've already filed.
Where is that?
My lord, I filed on 24th June 2020.
পরের ম্যাচটা কোথায়
The serial number, document number, lordship,
The The appellant has filed a certified copy of the decree of the trial court on 24/6/2024, which is taken in record, which is taken on record. Let the file be sent to the SR section for a further revised report in terms on the basis of the sorry.
Next Friday is a holiday.
This Friday.
This Friday.
Today is Wednesday, sir. On the next 70.
79. 69. Sorry, 69. 69, my lord, I am appealing for the defendant appellant. This is an appeal against an order granting of injunction in a partition suit where admittedly no document has been filed by the plaintiff showing their position at all. On the contrary, we have shown the document.
Partition suit by a plaintiff, co-sharer, position has to be proved.
Pause here for a moment, my lord. It is not our case is that they have no right at interest over the property. They have no, because prior to that, there is a partition before arrest record of rights.
Temporary injunction has been allowed.
Yes. Directing the parties to maintain status quo, nature, character, position.
Service.
Plaintiffs.
3 weeks.
Upon the plaintiffs only, my lord. Other defendants, because the injunction.
Partition.
Injunction sought for against only this defendant. Three.
Service 3 weeks. Next.
70.
My lord, item number 70, my lord, being led by learned counsel Mr. Anirban Tarafdar, my lord, I beg to appear for the appellants. My lord, today, my lord, Mr. Tarafdar was at court. My lord, he was informed in the afternoon that his father has fallen sick and he had to take him to the hospital. So, if perhaps my lord can grant us accommodation kindly.
Of how many days?
My lord, 1 day should be fine, and perhaps because he will be here tomorrow.
He has taken his father to the hospital. You don't know what would happen there.
Then, my lord, I'll pray for a week's accommodation, my lord. If it is possible.
Not this week.
Much obliged, my lord.
71.
71.
It is a lordship. This is my appeal against an order refusing to pass an injunction in respect of a suit for specific performance of an immovable property.
Agreement, specific performance of an agreement.
Agreement
in respect of an immovable property.
In respect of an immovable property.
Specific performance of the immovable property. What is
No. Of an agreement in respect of an immovable property. My lord knows after.
What is the nature?
My lord, it's a suit for specific performance.
I mean, what is the nature of the temporary injunction or ad interim injunction?
My lord, this matter has a checkered history.
I just wanted, what is the nature of the interim order you...
I'm seeking, my lord, as your lordship knows, that after the amendment to the Specific Relief Act,
forget about the law. I'm asking you.
So that he does just transfer, alienate the property.
That is what
yes,
I wanted.
Yes, my lord. Alienation. Against
why it is refused?
My lord will kindly see the impugned order.
Why it is refused?
I myself could not read the impugned order. It's in such a font. My lord, it's at page 33 of the 33 of the it's 33 of the stay petition, my lord.
The registered document agreement?
No, it's not registered.
How much it contains?
My lord, stamp duty 10 rupees. My lord, here I join an issue. My lord will kindly hear me. My lord,
tomorrow I will hear you. After
may I show the stamp act and
global, the latest judgment of 7 judges come. Let us see.
My lord, the stamp duty on an agreement for sale payable in West Bengal is 2 rupees.
Oh.
If I show, my lord, will kindly bear with me. I know, my lord, this is an issue, my lord. It is with stamp act. Well, I'll come back with the stamp act.
Tomorrow come. Let us see.
My lord will kindly see the amendment to section 4 of the.
We are also taken to surprise that it's
My lord,
rupees.
I'm not carrying the stamp act.
Anyhow, the next matter.
The next matter is also my matter, my lord. This is a matter, my lord. That briefed him. My lord, I am seeking injunction against alienation. My property encumbered by trespassers.
Next matter, no? 935
Lord, here the respondents are powerful political people of the present regime. As a matter of fact, a minister and his son. Your Lordship will see the cause title, the respondent number 2. Respondent number 5 is a company floated by the respondent number 6, who is the son of the respondent number 2. But instead of tomorrow, even the earlier matter, could it be on Monday, my lord?
Monday? You want this also to be on Monday?
But because, my lord, I don't think there is enough time, my lord.
Yes. कल के group 2 तो आगे करो.
Both the matters, my lord.
Your Lordship, mentioning for item number 26, the thing is, due to my mistake, I have mentioned the matter in behalf of the respondent, but we were for the appellate side.
But the earlier matter which I was
26.
Yes, Your Lordship.
Dismiss for default or
Yes,
what has
Your
happened?
Lordship.
কি হয়েছে ম্যাটারটা কি হয়েছে
Accommodation.
dismiss for default. Dismiss for
She is for the appellant. She is submitted that I am for the respondent. So dismiss for
Yes,
default.
Your Lordship.
Recall kore.
the other matter, the earlier matter, I know, my lord, there is a Justice Bhaskar Bhattacharya judgment followed by Justice Jyotirmaya Bhattacharya. They rely on the schedule to the act, Schedule 1A, and completely ignore Section 4 as amended by the state amendment.
Come. That is also a surprise to me.